2002. Which year's criminal bill?
20 ମସିହା
It will come before. Huh? May not come before.
hearing
Is in custody. You pursue the registry. If it comes under my roster, it will come. I can't give a direction.
another my lord 6 years sentence my lord 17 matter ଗୋଟେ ଅଛି 9 ର ଗୋଟେ ଅଛି ଆଉ
give it whatever matter.
my lord another my lord 15 ମସିହା ଗୋଟେ ଆଉ ଗୋଟେ 18 ମସିହା ମରି ଯାଇଛନ୍ତି ଦିଟା ଯାକ died my lord appellant died my lord
15 18 near died.
Huh?
Give
ସବୁଗୁଡା ଦେଇଛି ଯୋଉଗୁଡା
then like you write it.
Lord, I want to make a mention hearing item number 48.
Yes.
Lord, the file is missing. After 25 years, almost the matter is listed, and file is not traceable. But can we call after vacation?
Okay, after vacation. Okay.
Apply.
Yes. Yes. Start.
Item 1.
Please, let's see. My lord, an IA has been filed with a seeking
Sorry?
an interim application has been filed seeking a direction for extension of surrender date, my lord. Extension of surrender.
Last and final term, extended up till 5th of October.
My lord, in fact, Puja vacation is ensuing. That's why.
Okay, 10th October.
10th October.
Report.
Item 2.
Item 2
Died. Oh, sole appellant? So both the appellant died. Report is there, huh? Both the appellant died, huh? Abated in the absence of.
Item 3.
3 alive.
Report is there, it's alive, ready for hearing, lease the matter. Yes.
Item 4.
Died? Sole appellant died?
Again.
Okay. Sole appellant or how many appellants are there? Okay, sole appellant Sri Datta Saha has expired. Obviously expired and in the absence of an application under 394 ARPC, it's abated. Yes.
5.
5 to CBI also.
CBI. Pass it off. CBI. Let us see. Yes.
Item 6.
6 to give some time.
Yes. Report is not available now. Yes.
Item 7. Alive.
7 alive.
Alive. Ready for hearing. 8.
8 to report as
Report awaited. Yes.
Item 9.
9 the vigilance.
Vigilance.
Pass over.
Pass over. 10.
Item 10.
10 no they.
10 kona alive, huh? Yes.
11.
11 alive. They this.
12.
12 and 13. Report as.
12 and 13.
Yes.
Report awaited. Yes.
14. Alive.
Alive. Okay. Report is alive. 15.
Died.
Died.
No. 15 appellant number 2 and 3 are dead.
Sorry.
Item number 15. 2 and 3 are dead.
There are three appellants.
Yes.
2 and 3 died.
2 and 3 are dead.
One alive.
One, I don't have any instruction to that regard.
Sorry.
I don't have any instruction to that particular.
Get
Yes, sir.
Mrs. Subbalakshmi, that comes by the state on the basis of the report. Which report? Which is placed on record. Submits that appellant number 2 and 3 have expired. Therefore, the appeal to guard them stands abated in the absence of an application under 394 CRPC, so and so. How she further submits that insofar as appellant number 1 is concerned, she has no instruction as yet and seeks 1 week time to get instruction. Okay?
Yes.
Insofar as one. Yes.
16, and because some more time to get it.
Okay. Awaited. Yes.
17.
17 alive, Your Lordship. I have given the report.
Alive. Okay.
I am appealing for item 17. I may be supplied the paperwork in the form of sub.
Nothing will be supplied, sir. You have to take it. Where is your junior? You come and take in soft copies.
Order may be passed in this regard.
Yes, soft copy you can obtain. Yes.
Copy.
18, Your Lordship, appellant number 1 is dead, 2 to 5 are alive.
2 to
Given,
5 alive.
2 to 5 are alive.
1 dead, 2 to 5 alive. Yes,
19,
19 alive.
alive. Okay.
20,
20, Your Lordship, appellant number 3 is dead, 1 and 2 are alive.
3 dead, 1 and 2 alive. Yes.
21, died.
21, Your Lordship,
21 died.
died.
Sole appellant died, abated.
22,
22, my lordship, there are 12 accused, 12 appellant, out of them 4 have already died, and other, my lordship, 4 they are alive, and the other 4, my lordship, they need some more time to reconstruction.
Okay. You give the report, those who have died, abated, and those who have not died, Sarija Bana seeks further 1 week time to get instructions. Yes. Yes.
23,
Three, lordship, alive. Short matter, short matter.
Yeah, ma'am.
No, vigilance.
Vigilance.
Short matter.
Short matter in the sense,
Against the order of attachment.
anything survives.
1944 Ordinance Act.
Okay. What happened to the conviction?
Conviction, attachment order against it.
No. What happened to the prosecution?
Proceeding,
That part is
that part has not been,
Huh?
that part has not been.
That is
Instruction.
contingent upon that. You have to get the instruction. Get the instruction. The present appeal is arising out of the order of confiscation. There is
Not
attachment.
conflict,
Attachment.
proceeding.
Counsel for the appellant seeks 1 week time to ascertain. Then the counsel for the parties are granted 1 week time to ascertain the status of the prosecution once again.
Lordship.
You also get the status.
Vigilance.
Vigilance is good. Yes.
24,
My lord, in respect of item 1, my lord, that is criminal appeal number 252 of 2007.
252, 2007. There are 2 matters. Yes.
Appellant number 1 is already dated on 9/8/2024. I am filing the date certificate.
Okay. Appellant number 1. Andaru Sahu.
Andhar Sahu alias
Andhar
Subarchan,
Sahu.
because in death certificate it is written as Subarchan
Andaru Sahu, alias so has already
on
expired.
9/8/2024.
The learned counsel for the appellant has placed on record the death certificate, full stop, the appeal. Appellant number 1.
And with
That's
regard,
abated in the absence of application, so taken on record.
but with regard to
Placed on record degree.
yes,
Insofar as appellant number.
appellant 2 he is alive. And in respect of that sub item that he is already dead. That
Okay.
Another sub item that is
This is in 252.
252. Appellant 2 is alive.
Okay. Appellant 2 is alive. The matter is ready for hearing. Leave
Yes,
the matter.
Yes, ma'am. And in respect
What is the offense?
304 part 2 minor, convicted for 5 years and fine.
Okay. Insofar as criminal appeal 351 is concerned, the
Yes,
sole appellant,
Is-
sole appellant in this
Yes,
case,
yes, yes.
the sole appellant, Shailendra Sahu,
Sir,
Shailendra,
no, Balabhadra Sahu.
Balabhadra Sahu.
Balabhadra Sahu.
Balabhadra Sahu has already expired.
Expired, but I do not have the certificate,
Yeah.
but they are saying that in 2021 he's already dead. Because they are
Expired in
doing
the year
others.
2021. Statement, let the counsel for the appellant submit that expired on so and so, as such, the appeal in the absence of the application on so and so stands abated. Yes.
So lots of, a beg of fund.
351, the Balabhadra Sahu was died.
Uh-huh.
351 of 2007, Balabhadra Sahu was died. And Andhar Sahu was alive.
No. Andhar Sahu is dead. In the,
Certificate, I have seen it.
Ah,
Yes, ma'am.
yes.
You have any instruction in 351?
No, ma'am.
Okay.
But 350.
I have recorded the statement.
And in respect of 252 2007, only appellant 2 is alive and
Appellant, I know.
alive.
But,
Right. Yes.
so now out of these two, second one is
252.
abated. First one is abated, co-op appellant number 1.
Exactly.
Okay.
Obliged.
25, died.
So, appellant.
Sole appellant died. Report is placed on record. Yes.
26, died.
Sole appellant died.
26 sole appellant died. Report is placed on record.
27 died.
Sole
Sole appellant died. Report is placed on
28 alive.
live. ठीक है. 29.
29
appellant not received, my lordship.
Huh?
Report is not received.
Report awaited.
30
Malord, 30 Malord. Appellant 2 is died.
Okay, appellant number 2, and
Yes,
then counsel
correct.
for the appellant submits that the appellant number 2, Manik Sethi,
Manik Sethi.
Manik Sethi
Yes, Your Lordship.
is already expired. So therefore, the present appeal for him stands abated in the absence of application of the 394 APC. And insofar as the appellant number 1, 3, and 4 are concerned, the matter is ready for hearing.
Yes.
Release the matter.
Malord, paper book may be.
Counsel for the petitioner is permitted to obtain the soft copy of
Yes.
the paper. Take this.
Yes. Yes.
31 alive. 31 alive.
Alive. Okay. 32.
32
Your Lordship, 32, Your Lordship, there are 3 appellants, Your Lordship. Only in respect to 1 is instruction received. So far, other appellants 2 and 3 is concerned, there is no report is not yet been received, Your Lordship. Lordship, let it come next week, Lordship. In the meantime, I will file the
Okay.
instruction regarding the all appellants. Lordship.
Instruction abated. Yes.
33
33, Your Lordship. Vigilance matter, Lordship, 33, Your Lordship.
Vigilant.
Lordship.
Possible. Yes. Hearing. Start.
34
34, Lordship, matter is
Display board working. The file. Do. Who is appearing? You are.
34, Your Lordship, matter ready for hearing, Your Lordship. Our reports already been filed.
Matter ready for hearing. Are you ready or not?
Yes, Your Lordship.
Who is appearing here? Mr. Ragoda. There are many appellants are concerned there. So keep it aside. Let us see. Let him come. Get ready. I'll proceed with the 92 matter. I'll proceed with the matter. Okay. Next.
35
I don't mention item number 12.
12 is over already. 35.
Hello, my lord. I don't mention item number 12. Only 2 weeks.
12 is over. Long back. You send someone. Yes. Item.
35 also reports.
Yes.
submitted, matter
Here
is-
which matter?
Pardon the mention, item 30.
30.
Yes.
30.
So the
appellant 2 died.
Appellant 2 died and so far as the matter
Dad,
2 has died.
no, my friend, actually what happened, my lord? Earlier power is there. So after inspection by the local IAC, I inquired the matter. Well, coming to know about the appellant that nobody is appearing in this case, he has sent me Moklahoma. I have appeared. Lordship,
Now you want to appear. So both of you are appearing. What? You.
I have not taken consent from him.
You want to take consent, take consent and file it.
No, I am not interested. No. Because the client has sent me, I have power, I have file power. My friend will argue. I
You
don't know.
sort it out and tell me. So
Oh,
that-
yes.
Yes.
He is argue, I don't have any objection.
No, sort it out.
Yes.
Yes. Okay.
But file power.
Yes.
35
35, Your Lordship, report already been submitted, matter is ready for hearing, Your Lordship.
Three 307 4 years. Who was appearing in this? Asutosh Mohanty. Makishkuri was appointed as Asutosh Mohanty. Huh? How frequently will change? Mr. Ragada has come. The fellow wale. Thank you too.
Sorry for.
It's all right.
No, in this case, what happened, my lord? My lord, there are three lordship initially directed state council to obtain instruction of whether any status of the accused persons, my lord. And some of the accused persons expired in the meantime. That has been noted, my lord. That is
Yes.
report has come, my lord.
Yes.
Case against them abated. So, for another two things, my lord, while the case is pending before this court, my lord, informant came forward and filed an application for compromise. Since offense 395 is there, my lord, for that this one would direct him to approach the state for withdrawal of the case, my lord. That report, my lord, last time also. And another thing, imbue issued by this honorable court, whether that has been executed or not. That is two things, my lord. Last time, lords will taken a view that even if imbue issue, lords can pass order, my lord.
Yes, that's
My lord.
in.
My lord. But
what
one
if-
thing, my lord, whether state government withdraw the case, that is, my lord, if the case is withdrawn, my lord, then we have no
That is reflecting in the order. Just see.
order sheet, my lord. That is
So many orders.
4/9/2025, Your Lordship. So directed to comply with 10/7/2025.
10/7 detail like heights.
10/7, Lordship, there is, though, there is order. So, but.
Have you written any letter pursuant to this?
Yes, Your Lordship, but not yet.
Huh?
So far regarding.
I can't wait now. I can't wait.
What
I
happened
can.
in this case, though the enrollment already issued, it means the remaining.
That's not the issue. Issue is something else.
That's the matter. Now. the-
Only thing is whether informant approach the state government for withdrawal of the case, and that is their question.
Where is that order?
Or that is, my lord, in order that 10/7/2025 that has been mentioned, my lord.
10/7.
27. In first line, my lord.
Hmm. 24/3/2003.
My lord.
Just see the order. 24/3/2003. Sri Ghosh, learned counsel for the counsel appearing for the appellant submits that dispute has been settled and all other offences except 395 are compoundable. Since there is space in the village, peace in the village, because of the settlement, the step may be taken by the state government to withdraw the case.
Exactly.
I express no opinion in this matter, and it is open for the state government to take any decisions to withdraw the case, and unless appropriate application is filed on behalf of the state for withdrawal of the case, the said questions cannot be considered. 2003.
They are right there. That part, they also have no instruction whether they before the entire.
When 2003, we are in 2025. State has to, and who is responsible? I'll tell. 2 o'clock. I'll call him to appear. I'll not wait.
What happened? You also
May-
next
may-
part to argue, my lord. Allow me argue this case, my lord. Because, my lord.
No, 2 o'clock. I'll ask the
My lord,
SP to appear.
Exactly.
With this.
If that has been withdrawn, my lord, nothing, my lord, else.
Who is this?
Say one.
Huh.
Though the since one.
Just read my last order.
I've gone.
Please read my last order. Please read my last order.
Yes, yes, Lord, I have-
It is made clear that in the event the order is not complied, necessary adverse inference will be drawn against the prosecution.
That's that.
What is the adverse then? I will not comply my order also.
No, I'm not saying.
And then
Make. One.
who is SP of that area? Tell me. Which area?
Now on good, my lord.
On good.
On good.
SP on good to appear at 2 o'clock.
That's okay, make.
Yes.
Say one thing also. What happened?
I can't leave.
Accommodate for the day, Lord. Only my.
I am acceding to your request. You are asking for a 1 day. I am giving you half day. That's the difference. Instead of 1 day, I am giving half day. 3 o'clock. 3 o'clock. Let him appear.
That's okay, not.
You will understand it. For your good, I am telling you. Let him come at 3 o'clock.
Within 15 minutes,
SP,
you also, once upon a time, you also direct me while as a state council with Mr. Ragada would take issue within 15 minutes in that Bharatpur case.
Yes. This can't be tolerated, you know. 1992 petition, 1992 appeal. I can understand if the defense is not coming. The prosecution is not helping the court. You just simply tell, I'm not going to send him to jail.
No, I'm not saying that.
So at least things will be taken in right spirit. Tell him to appear at 3 o'clock. Okay, 3 o'clock.
Two things, my lord. My lord, the immutable whether executed or not. Second thing, my lord, the withdrawal, regarding
Yes,
withdrawal.
Lordship, dispensing the personal friends, I have only obtained the instruction from the concerned.
If instruction comes, it's all right. Otherwise, let him appear
Lordship.
through virtual mode. I'll ask him, what is great deal about it? Why are you so defensive? I don't know.
No, I'm not dependent.
He will come and I'll just simply ask, what has happened? Please do something. Then HP appears, everything will be fall in line. 3 o'clock.
3 o'clock.
Let him come. Yes.
35.
See, if the government have withdrawn the case,
My lord.
then the appeal is infructuous. Unnecessary, we will waste time on this. 2003, something might have happened. Who knows? I know if he appears, he'll seek for time, but let him seek the time, not you.
One thing, my lord, I'm more than one. He will take instruction whether there is show that there are Korea relations in the village, my lord. It will be better you writing the judgment, lordship. If there are Korea relationship, then it will be better case for her.
I'll acute everybody.
The case is actual, my lord.
3 o'clock, get ready. If you get some information, it's okay. Yes.
35.
35. 35 note is there, no? Who is ready for hearing?
55.
55 ready? Yes. 55 for. These are old matters. When this will be 2006. So tell the orders.
I
which order.
have gone through that. 2003.
One have to understand whether government is withdrawn or clarify. Government is capable only can
Might have withdrawn also.
public
Because only public prosecutor can move application, nobody else.
they are in the car.
On the instruction of the government, public prosecutor has to move the application. That's the reason the court has passed the order. Yes. Yes, sir.
My lord, conviction is for 341 and 324. Simple instrument 1 month, the 2 years for the 324 IPC, my lord.
1 minute. This is 350, 551 of 2006. Okay. Under section?
Convict under section 341 and 324.
341, 344.
Simple instrument 1 month for 341 and RI for 2 years for 324.
324,
Yes,
2 years.
yes.
Yes.
First, my lord, FIR. FIR was lodged by the one unknown Charana Sahu, my lord.
Yes.
It was registered at 2 p.m., my lord. Incidents took place 12:30.
FIR it is 2 p.m.
Yes. The incident took place 12:30.
Incident taken place at 18, 9/23.
2003, my lord.
Sorry, 2003.
And the FIR lodged
At 2 p.m.
2 p.m. on the same day, my lord.
Incident at
12:30.
30. But it's a half a kilometer distance.
Yes,
Okay.
half a kilometer.
Yes.
And the allegation against Arun Kumar Patnak and his two brothers. Also, his father's involvement is there.
How many appellants are here?
Here two,
Two. That is
Arun and Ishan.
Arun and
Ishan Kumar Patnak.
Nissan. Arun, Nissan. Yes. Yes.
The first PW6 is the IO. I also statement on this ground, this case is a acquittal case, my lord. PW6.
PW6. You see the IO statement on the basis of that you will
Take
be-
रहे case sir.
Okay, let us see. PW6. PW6. What does he say?
Why I am saying so, my lord? Because firstly I get up to the occurrence, my lord. He is saying, my lord, may I read, my lord? On 1893, I was SI of police, both PS, on that day at 12:30 p.m., my lord. On the written report of the complainant, Annam Sahu registered the case and directed me to take up investigation. Where the FIR is lodged at 2 p.m., my lord.
On that basis, he will be acquitted.
Others are there, my lord. And
he might be referring it to the incident. It is a 1 hour difference here and there.
No, my lord. It is also corroborated the CD, my lord.
On that day at 12:30 p.m. on the written report of the complainant.
Yes.
See what happens is the written report is given. By the time it is formally registered, it may be 1 hour late or 2 hours late. It is 1.5 hours late only.
But it's consistent with CD also, my lord. CD will be
That can't
12:30.
That can't be so,
Yes.
so important that at least the FIR can be doubted.
The case, my lord, total 6,
What
7.
is the incident, you tell me?
Incidents, my lord. The informant along with the pillion while driving the motorcycle, the present appellant and others came to there and assaulted in the breeze, my lord. And at 12:30. That eyewitness, who was the pillion driver, turned hostile, my lord. PW1.
Okay. Who is doctor? Doctors.
Doctor is PW7, my lord.
PW7 doctor. Come to doctor.
Yes, PW7.
What does he say?
She is reading, my lord. She is stating about the injuries, my lord.
Doctor only say
Injury, nothing about the seizure of weapon or that may be caused.
Right.
Yes, my lord. And the
3 lacerated
yes,
wound.
lacerated injury,
abrasions.
lacerated injury, abrasion. And interestingly, that doctor has examined on 2 p.m., my lord. He has examined the injured at 2 p.m.
Yes.
And see the injury might be between the within 12 hours, my lord.
Who is the injured?
Injured is the informant. PW1. Sorry.
Let us see the PW.
PW4.
PW4 is the injured.
Injured.
Come to PW4.
On married marriage.
See, at the top you say he writes on 18/3/2003 in between 12:30 to 2 p.m. While so then see the timing is with everything has happened within 12:30 to 2. FIR, the assault, thereafter the doctor's test, everything.
No,
is
man.
done. And that is within half a kilometer. Everything is.
That means the FIR must have been lodged after 2 p.m. my lord. Because he is saying on 1893 in between 12:30 and 2 p.m. while I was returning from Bodh, my lord. By the motorbike, the accused persons wrongly restrained me at Tutusinga. In spite of their attempt to restrain, I didn't stop my vehicle and proceeded ahead. The accused person staged after me by a motorcycle holding a tangi. At Mahanadi Bridge, both the accused persons overtook me and out of fear, I turned my motorbike and went towards both PS. Just near both gas.
Arun dealt with 2 tangi blows.
Yes.
On my head.
Yes.
Okay?
No alternative.
Stopped my vehicle.
Due to those blows, I sustained bleeding injuries. Then I
one tangi blow on my left palm.
And in this
what Ishan has done. Then two blows on the head and 1 blow in the palm. Okay. Come to 7. What does he say? Where the injury is found?
On the injuries as per which it's for 9.
Laceratory injury might have been caused by in the parietal bone, simple in nature. Laceratory injury, 1 inch lateral right petal bone, which was simple in nature. Laceratory injury on left palm, which is simple in nature. Abrasion of size, right.
All are simple.
All are simple.
All are simple. Okay.
And that seizure of weapon not supported by the
Come,
witnesses. my lord.
then you tell me what is attributed to Isan.
It's as per the FIR made in the fist and kick blows.
No, PW4 you come.
Middle 4. Enter thus one method, Bangalore, find no only allegation against Arun my lord. Accused Arun dealt 2 tangy blows. Arun gave me tangy blows to my left palm. Due to those, I sustained injury. On being
And it
said,
doesn't say anything about
yes,
Isan.
yes.
See, the injured witness has very categorically named Arun.
Yes.
And he says 3 blows.
Yes.
2 in the head and 1 in the palm.
Palm.
And that stands corroborated with the doctor's evidence PW7.
Yes.
And insofar as your biggest defense is time is concerned, the time will not help you because everything has happened within 12:30 to 2 o'clock.
As well as the seizure of
Even the
weapon.
incident happens, the injured says the incident happened between 12:30 to 2.
Yes.
And FIR is registered at 2. And in the FIR it is written that incident takes place at 12:30. Then what? And the doctor also examines at 2
No,
o'clock.
I'm still.
So these are minor.
No, my lord. Other as they are married. Seizure witness has been not one turned hostile and one has not like
Your biggest point is the pillion rider who was going with the
turned hostile.
Injured. Who is the pillion rider?
PW1.
Injured. PW1 is
Pillion driver.
the pillion rider. Huh? Pillion rider. What does he say? Pillion rider.
Turned hostile married.
No, hostile.
No, not hostile.
What does he say?
Not yes, I'm reading.
Hostile means.
I know the informant, but I don't know the accused. Persons who are standing inside the dock. About 2 years back, on a particular day, at about 12 a.m. at Kiakara, I asked the informant for a lift in his motorcycle while he was proceeding towards both. However, on the consent of the informant, I sat on his motorcycle and came to both where he purchased some sari. Then we both returned back to our village to Sat. On the day, I was dodging behind the informant as the pillion rider in his motorcycle. I don't know anything about this case.
So to that extent, the story of the prosecution gets corroboration. The fact that in 12:30 this has happened,
Yes.
and the fact that he was going in the vehicle of the informant
Yes.
as a pillion rider, that part of the story is stood corroborated with the PW1. Even if he says that I have not seen somebody is giving blow.
He is saying nothing.
Leave that part. Leave
Yes,
that part. You
yes.
can't discard the hostile witness in toto. You have to see what are the statements and see the cross examination. The cross, what does he say?
It is not a fact that I have stated before the police that on
No,
at about
that's-
11
that's
a.m.
it.
And he has not been examined as a police matter.
How much you want to go?
28 days. Madam, PW4, paragraph 4, madam.
Yes.
Last 3 lines, madam. However, got it, madam?
Para 4, huh?
Yes.
Yes.
However, I myself came to the Bodh police station by my own motorbike. About 15 to 20 minutes after I lost the affair, the local police brought accused Arun to the PS, madam. And the appellant arrested on 19/9. Pune is not arrested, but he's saying after 15 to 20 minutes after the police arrested.
He registered the FIR. How does it make difference?
On the date of
Next day, the appellant was arrested.
Yes, But he is saying ki on after 15 to 20 minutes
What is 15 to 20
of
minutes
lodging of the
after
FIR.
I lodged the FIR. It's all right. FIR might have been lodged in
No,
18.
no. See,
He was arrested, the accused is arrested next day.
no. About 15 to 20 minutes after I lodged the FIR, the local police brought accused Aruna to both police station and I recognized him.
Okay. Show me the charge sheet when he was arrested. Show me the charge sheet. Final form.
(1993) at 11:30 a.m.
Or of arrest. Okay.
And
PW4 says Arun,
Yes,
Arun, para 4, huh?
yes.
Para 4. Arun was brought to the court. Brought to the court after
15 to 20 minutes.
15 to 20 minutes. Huh?
After the lodging of the FIR.
After lodging the FIR. But charge sheet shows he was arrested on 1999 2003. See the come to the IO PW6, huh?
Yes, madam.
Come when he is saying he is arrested. He is arrested.
See, he is saying on 19/3/2003 I arrested accused persons near that bridge. Near that Mahanadi bridge and for
Para 4 he says that IO says even IO.
Yes.
Para 4 for PW6 also says arrested on 19/9/2003. But I tell you, he might have been brought. But depending upon the nature of the FIR and all, next day he was arrested.
No,
bringing him the accused to the police station doesn't mean arrest.
But
PW4, the injured says after recording the evidence, recording the FIR, within 15-20 minutes the police brought the accused to the police station. But he doesn't say that he was arrested. The arrest had taken place next day. He might have been brought. Bringing him to the police station doesn't mean that he's arrested. Formally, he might have been arrested next day.
But he was arrested from the Mahanadi bridge, my lord.
Next day it was shown. When
then what is the change in circumstance? The 18 and between
accused persons near Mahanadi.
Bridge. 18 to 19, what is the change in circumstance? Because the FIR was same, my lord.
Para 4 on 19/3/2003, I arrested the accused persons near Mahanadi Bridge and forwarded them to court. The accused.
That's what he says.
Yes.
If they were arrested in Mahanadi Bridge, injured says that the same accused persons were brought to the police station on the same day. And the next day, how they are arrested in Mahanadi Bridge?
And
then either the informant is telling lie or these witnesses are telling lie.
There are the accused Arun Kumar Patnaik, while in police custody, confessed to have concealed the weapon of offense in the pond.
That he was in the custody of police on the same day. He was in the police custody in the same day. Because PW4 is very clearly saying that. Para 4, PW4, come. I myself came to the
Came
both
to
police station by my
my
own
own
motorbike. About 15 to 20 minutes after I lodged the FIR, the local police brought accused Arun to both police stations and I recognized him. Then where is the occasion for the police to arrest him in
Yes, sir.
somewhere else next day?
He may not have been arrested.
These are manipulations by the police.
And on paragraph 3, my lord, he says, I don't know the accused person. I have no prior acquaintance with the accused Aruna,
Who?
the injured informant himself. Paragraph 3, my lord. Paragraph 3, middle, my lord. I have no prior acquaintance with the accused Arun.
Maybe.
But charge sheet shows that they have business relationships, my lord.
Huh?
Business relationship they were. And against the brief story of the brief fact of the charge sheet, my lord. That the complainant Aruna Annam Charana
It's
Sahu.
not a fact that I was doing business with the accused Arun prior to the occurrence. Only after the arrest of the accused Arun by the local police, I could know him.
But can have answer charge sheet, my lord.
Charge sheet, who is the author of the FIR? Who is the author of the FIR?
FIR is the informant himself, my lord.
He says that I was.
Yes, I am reading, my lord. That the complainant Annam Charana Sahu is the accused person and the accused Aruna Patnaik and his brother Kishan Kumar Patnaik had previous friendship and they were jointly indulged in clandestine business like from potting ganja, etc. In the process, Arun Kumar Patnaik was due to pay some amount to the complainant, which he avoided and didn't pay. Under the circumstances, enmity developed amongst them, and both seek opportunity to assault the other.
Yes.
Exhibit P for Caesar Open.
Caesar witness, two Caesar witnesses, one turned hostile and another not examined, my lord.
Caesar witness, who is Caesar witness?
Yes, I am, my lord.
Exhibit?
Exhibit 3. Witness Krishna Chandra Pada.
Weapon seized, huh?
Jitendra Pada.
Weapon seized. Seized.
Two witnesses, my lord.
Two witnesses.
Jitendra Pradhan.
Jitendra Pada, Krishna Chandra Pada.
Jitendra Pradhan is PW3.
PW?
3.
3.
Turned hostile.
Turn hostile.
And another is Krishnanda Pradhan, not examined.
Yes.
And the weapon offense was not produced before the doctor. He is saying nothing about the weapon of
Not
offense.
produced before. Yes. But all these things, against Ishan, there is nothing. Against Arun only everything is there. Ishan against that's nothing. And they have undergone 28 days, huh?
Yes. 23, my lord. They were arrested in 2003 and released on bail 1710. Also, our High Court granted bail.
So then your major argument is arrest is doubtful.
Doubtful.
Second is the relationship between the accused and the informant,
Yes.
the injured,
Yes.
is doubtful because in the FIR he says that I had a business relationship,
Yes.
and subsequently para 3 of his evidence he says that I didn't know them first time I saw them.
Yes.
And third is the seizure of the weapon
Yes.
is done in front of two witnesses. One witness is not examined by the prosecution, the other witness is not supporting the prosecution case. Fourth is the weapon of offense is not produced before the doctor to suggest whether this
Yes, yes.
weapon can cause the injuries or not.
Yes.
Fourth would be to say that the pillion rider, that is PW1, has not supported the prosecution case.
And he is not saying anything about that in the FIR also, my lord. The informant is now saying about the pillion driver.
His presence.
Yes. As well as the
PW1's
thief.
presence. Okay. And the last but not the least is you have undergone 28 days and injuries are simple in nature.
Yes.
So it can't be a case of 326. It may be a case of
It has been 324, my lord.
to 324. It may be because 324 could have been if the weapon, seizure of a weapon would have
Yes,
been
yes.
proved. In the absence of proving the seizure of weapon, which is doubtful, the injury sustained by them being simple in nature, it could be a case of 323. If it is 323 and 28 days you have already undergone, so we can convert the sentence to already undergone. But insofar Isan is concerned, there are two appellants. Isan is concerned, there is not an item of evidence against Isan. Isan is liable to be acquitted. Acquitted. Okay? Acquitted and Arun 323. 323 IPT undergone. Huh? Okay.
And I was relying upon my two judgments, but I could not brought my lord regarding seizure.
Caesar, I accept it.
Yes.
See, there are two witnesses. One is not examined. The other one is saying that I have not seen. That's PW 3.
3. Out of 7, 3 witnesses has been turned hostile. Only I.
PW 4, IO and doctor.
1, 3, and 5.
I know. They've gone hostile.
Yes.
But the PW 4, 7, and 6 supported the prosecution.
4 is the informant, of others
4
are
is the
official.
informant, doctor is 7, and 6 is the IO. And the rest of the witnesses have turned hostile. Very poor case. May lead to an acquittal also. Evidence design, sir.
Obliged.
Yes.
From 50.
Which one?
51.
50?
50.
I was appointed in 4th match. Also pleasure over.
So the rest you take his name and appoint in a couple of matters. Yeah? That's what I want, that at least who is assisting, he should be given option so that we can finish that. Huh?
158.
Satyanarayana Mishra, 4. Appoint with what, yeah? You take the file, yeah? And be in touch so that wherever I appoint it.
40, 40.
Yes, yes sir.
40. Item 40.
40.
I mean, 40.
Okay.
Two appeals, my lord.
Two
Two
different
appeals.
appeals.
Two appeals, my lord. Two persons convicted
for the offence under section 454, 380 and 34 IPC. My lord, for the offence under section 454, 2 years, my lord, and 5 years, my lord, 380.
2 years for 454
5
and
years,
5 years for 380.
380.
Okay.
My client, my lord, working as a, my lord, Sirastadar at the time of occurrence, my lord. And the appellant, my lord, I am appearing for the, my lord, Doitari Bhat in CRLA.
And who is appearing for Kalicharan?
158.
Kalicharan, who is appearing for that?
158, my lord.
No, 158 you are appearing. Who is appearing for 154?
154, my lord, means the Dikti Rakha Nanda, my lord, appearing for the.
The caller so that we can hear together. Caller. I'm passing it over. Caller. So that we can hear together. Because same appeal, same thing. Yes.
My lord, 52 item may be taken up at 2 p.m.
Which one?
52. I'm ready. Vigilance wala nahanti.
Asan, we don't know.
52,
Ah,
56, the both are.
No problem.
Well,
Call. Madam, you are ready? Which item? 40.
Lordship, in item 36, Mr. D. Naik will be appearing first. So he is in accommodation for his father bereavement.
Sorry?
He is in accommodation till 23rd for his father bereavement. So the date may be fixed after 23rd.
Father?
Bereavement.
Who's?
His father filed the vehicle. D. Naik's.
For the party. Yes. And one CBI matter was passed over. Just see, tell me.
Item 5, Your Lordship.
What is the instruction you have?
Your Lordship, we have not received any instruction yet. So some more time may be granted.
Yes, madam. She is saying something. Yes, sir.
Item 41. Almost the book that guide. 55 was going. I'm ready to do.
Then I'll take it up. Because nobody was there, then whoever is there, I'm picking up.
Very fast.
Yes.
Item 49.
49. You prepare some note. Very good.
Your Lordship, I'm for the petitioner in item number 49. I'm for the petitioner, Padma Lochan, in item number 49.
40.
9.
You are appearing for whom?
On behalf of my senior, T. Mishra, Tapan Mishra.
On behalf of?
My senior, Tapan Mishra. Your Lordship, we were not aware that amicus curiae has been appointed in the matter.
The letter argue now. Yes. Yes.
Sir.
Yes, madam.
Yes, Your Lordship. Your Lordship, the appellant Padmalochan Mahanta, who is about 26-year-old at the time of occurrence, Your Lordship, and was convicted under section 376 of IPC, and the conviction was based on judgment dated 26 April 2002, Your Lordship.
Yes.
By Sessions Judge Barikuta in Sessions Trial number 8/31 of 2002, Your Lordship. And the appellant was sentenced to rigorous imprisonment 7 years in 2005.
7 years of 2000. Yes. Yes.
And my lord, the appeal is against your.
With that, with the girl was saying, you sit down and note down what she is arguing. Okay? You sit and note. Yes.
The entire prosecution based on the sole testimony that is victim one statement. There are 14 witnesses, prosecution witnesses.
Okay.
And out of 14 witnesses, the doctor report is the whole contention, there is the doctor's report. Because there was the doctor's report suggested that there was no injury, neither in the internal part of the victim and the accused, nor in the external part. No, all over the body, nobody has some single injury also found.
Incident has taken place on 22/6/2001. Terrible incident. Victim discloses the incident to her mother and
FIR lodged on 26/6/2001. And your lordship, the
You remain in the custody for a very long time?
yes, your lordship. 4 years.
4 years, 8 months.
8 months. Released on 19/9/2005.
Yes, you've written. Very
Yes,
nice, very nice. Yes. 14 witnesses. Yes. Let us see the PW1. Huh?
yes, sure.
Let us read. PW1. It sees the prosecutives.
Prosecution.
Yes,
I read this one.
yes. I am the victim and I am.
I'm the victim.
Victim and information.
Yes.
You are 12 years old, huh? Which portion you want to read? Read. Which portion you want to read, you can read.
False information also.
Hmm?
Your lordship, the thing is that I just want to give instead of this quote, your lordship, that when as per this FIR, your lordship, she stated in her statement told that the accused pulled her inside the jungle and raped her there. Rape, but there was no injury. So your lordship, and closed her mouth when she started crying to scream, your lordship. So my question is that why any kind of injury, any bruise, or any kind of redness, nothing found on the body of the victim?
Yes.
So the
You are indicating towards consent. You are indicating towards consent.
yes, your lordship. Consent
See-
of false your allegation.
You be sure whether you are saying consent or false implication. Consent has a different connotation altogether because the problem is she says that she was 12 years old. So is it your case, it is a consent or it is a false implication? It is false implication. Okay.
The
You
accused
pull down my pant, me and ground, sit over me. The accused closed my mouth by putting his hand. The accused tried to himself, but
Tend not to disclose anybody else.
yes, you, but there is no such evidence given towards that. Only the statement is there of PW1. And no eyewitness, no one else.
after 4-5 days
Yes.
of the incident, I disclosed the incident to my mother. My mother went to the house of the accused. So matter, and but the accused could not tell anything. Thereafter, I was orally reported the. So incident taken place on as per your this thing 22 and the FIR registered in 27. Okay, the delay of about 4-5 days, 4 days, sir. 4 days delay. 4 days delay. Okay. Mali, Hare Krishna, and other people were examined.
Yes.
Have they supported the prosecution?
Yes.
Huh? That part of the story is believed because mother, Mali, and Hare Krishna, and were going with this girl. And when the rain came, then this accused came and asked her to give lift. And these three people have let the girl to go with the boy. And then the incident takes place.
In this, the mother and the one, they told that the accused offered them the permit. But see, he stated that the mother told the accused, take fine. That is the
Anyway, whether she asked thereafter the boy has taken or the boy has himself has asked to take, these are the not very minor variations. From the evidence of the PW1, the victim, prosecutrix, you want to show that there is delay of 4 days in registration of FIR, and the narration of the incident, what she says, that there was some physical resistance by the girl herself while the incident had taken place. If there was some physical resistance, it is not reflecting in the medical evidence. That's what your case. Yes, next.
And your lordship, there
Who is doctor, PW?
PW 11 and 12. 11, 12. 11 is the doctor who examined the victim, and 12 is the doctor who examined the accused.
Yes.
No sign of recent cohabitation also stated in the medical report.
We'll go there. Huh?
It was on medical examination was on 28.
Yes.
Okay, we'll see. See that. Victim, a PW. Who is PW2?
PW2 is the Mali Monta, your lordship.
That Mali, who was there with
Yes.
in that. What does he say?
Or mother.
Mali mother is 5, sir.
At that time, the accused came on a cycle and told to give lift to PW1, to which the mother of so and so agreed. The accused PW1 cycle so and so. This part is corroborating. Okay, next PW3. Mohandra Monte. Who is he? Father. He says 3-4 days after returning from the weekly market, my wife informed me that the PW1 was coming on the motorcycle of the accused near so-and-so inside the forest, and the accused committed sexual intercourse with PW1 with her consent, without her consent. Okay, father. Father also supported. And PW4? Biranji Monto, who is he?
Piranchu, post occurrence witness.
Lordship, item 34, Lordship, please kept it 3 p.m. And Lordship, I will bring the notes of the item 34. In 34, Your Lordship, we have already filed your instruction and well-beings of the all appellants, Lordship. As per the instruction, there is the clear report is that out of 28 appellants, 10 of the appellants already expired and remaining appellants already been released and premature, Your Lordship. And one more thing, Your Lordship, I am bringing the notice of the 320 on the CRPC, Your Lordship, for withdrawal of the case, Your Lordship. That too. May I read your 321 so far, Your Lordship?
What do you want to say?
Lordship, my respect submission, Lordship, as the appellants are already been released by premature release by the government, now the appeal has no force, Your Lordship. That is me to bring the notice of the court.
3 o'clock you tell me
And so far, withdrawal of the case, Your Lordship, I am to bring the notice of the 320.
whether an application was moved by the prosecutor or not.
Lordship, that effect I am
Where is premature release? The report doesn't say that prematurely everybody is released.
Yes, Your Lordship.
What was the sentence?
Sentence, Your Lordship, 3 months, 3 years and 2.
All of them have undergone 3 months, 3 years. All of them have undergone the entire period. No, I'm just asking whether premature release means what? They have undergone. Oh, premature release. Who was sentenced 3 years?
3 years, Lordship.
Which appellant? Thirty-four, huh? No, 3 years. I'm talking about 3 years. You say.
Except these 4.
Except?
Except, Your Lordship, Prabhat Das, Pitambar Sahu.
Except Orokito, and everybody was sentenced to 3 years. All of them were convicted in 395.
No, Lordship.
Does not affect the legal except Orokito. Then all of them were released prematurely. Yeah? Okay, then what you want to say is, since they were released prematurely, so therefore, no application under 390 for compounding is might not have been moved, withdrawing the prosecution. Yes, no, compounding is not there. So therefore, this court has asked whether the state government is willing to move application for withdrawing the.
320.
I don't know. That is the order 2003. It has to be complied or not. That's what I'm asking. I'm not examining now whether withdrawal is permissible or not permissible.
2003, Lordship, kindly glance for a moment about that order. Kindly glance
Subsequently, NBW was issued against them.
in 2016, Your Lordship. Then order was issued in 2016, Your Lordship.
The report is dated
4/8/2025, Your Lordship.
so that there then these people might have been arrested and thereafter they remain in jail and prematurely they will.
As per the report, my lordship, and they are guilty.
Okay. I read it, don't worry. Give, 3 o'clock, give me, dispose it. Dispose it. Yes.
There is no need of normal consent.
Yes, 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 yes. Which item? Yes, Ms. Acharya, which item number? $54. Yes. Three, 4, and 5 remain, huh?
My
Rest
lord.
died.
1, 2, they have died.
Hmm.
They have died. 3, 4, 5. My lord, here the charges were under section 498A, 304B, 302 by 34 IPC, and section 4 of the DPI.
Yes.
The trial court has acquitted the accused persons under section 302 and 304B,
Yes.
and convicted the accused, all the accused persons under section 306, 498A.
1 minute. Yes. Appeal number 345.
My lord, 345. Convicted them under, acquitted them under section from 302.
And who is 3? 3
Huh?
is
3 is Manju Jana. That is the sister-in-law.
sister-in-law. Yes, 4.
4 is the husband of the deceased.
5.
5 is his brother. Brother-in-law.
Brother-in-law.
Of the deceased.
And it is a conviction under 306.
498A.
498A.
306.
Ah.
And section 4 DPI.
Okay.
By 34. The maximum sentence under section 306 was given at 3 years.
3 years.
Yes.
498A.
498A, 2 years.
Huh?
2 years.
2 years.
And
Yes. 4 DP.
I think it is 6 month. 6 month. 6 month. And fine of rupees 1,000, 1,000 and 3,000 respectively.
Okay. Yes.
Well, I just the prosecution case is like this. The marriage has taken place in July 1998. The deceased and at the time of marriage there was a demand of 10,000 rupees, out of which 5,000 was given. Rest 5,000 was not given, for which she was tortured, and ultimately she died on 2000. And on 2000, that is within 2 years of her marriage.
Yes.
So, my lord, the learned trial judge on analysis of the postmortem report came to a conclusion that it is a case of suicide. Then, your lordship, I just like to take your lordship to page 7 of the judgment. That is some findings, and then I will raise my arm.
Yes.
Page
Para 7.
para 7.
Yes.
Last para. Before going to consider. Your lordship got it?
In para 7 only?
Yes.
page 7 of the judgment, that before going to consider the evidence of PW1, the word sentence begin with.
Before going to read it, let's see. Fine.
It's, para not para 7, my lord, that is para 8.
8 para 8, yes. Before going to. Yes.
Before going to consider the evidence of PW, because in para 7 he has considered about the postmortem report and came to a conclusion that it is a suicide, not homicidal death, this is a suicidal death. Before going to consider the evidence of PW1, 2, 5 and 8, it is pertinent to place here that in this case, the marriage of the deceased Prabhati alias KD with the accused Dinabandhu in the month of July 1998, her death within 7 years of her marriage has not been disputed either parties. It is contended by the learned defense counsel for that Nandu Sahu, in whose house the marriage proposal was finalized, the mediator Salila Sanju Jena, in whose presence 5,000 is stated to have been paid to the accused Duryodhana, and inquiring officer of the UD case number 4 of 2000 are in since not examined this case after the death of the deceased, though information in writing was given at Mangalpur police station from the parent side of the deceased. The said written report lost from the parent side of the deceased has not been brought to the record. The prosecution case suffers from non-examination of the material witnesses and suppression of important documents. In this regard, it is considered as there is no evidence on record that Nanda Sahu and any of his family member was present at the time of marriage proposal was finalized, and to mediator Salila and only in presence of Boju Jena, rupees 5,000 stated to have been given at the time of their non-exam at that time. Their non-examination would not affect the root of the prosecution case. So also the earliest point of time, Goloka Chandra Jena, PW7, the elder brother of accused Dinabandhu, lodged the report, Exhibit 6, Mangalpur Police, stating about the suicidal death of the deceased in the house of the accused person, basing on which said UD case number 4 of 2000 was registered, whereby the law was set into motion. Any subsequent written report, if any, lodged at Mangalpur police station concerning the case matter would not have been taken the place of FIR of the case, but they be treated as a previous statement of the maker thereof. Non-availability of the stated report cannot be treated as fatal to the prosecution case. Hence, the contention of the learned defense counsel seems to have no right weight for the reason stated above. Coming to the evidence of PW 1, 2, 5 and 8, it is seen though the prosecution has clearly placed on record regarding demand of rupees 10,000 as dowry from the side of the bridegroom to the bride side, the time of finalization of marriage proposal of the deceased accused Dinabandhu in connection with the marriage agreed rupees 5,000 and paid the balance 5,000 as assured to be paid later on convenience, but 3 to 4 months after the deceased remained in the house of the accused persons, demanding the rest unpaid dowry amount rupees 5,000 from the parent of the deceased. The deceased was subjected to torture, harassment and assault by the accused persons, for which she, having come to her parents' house on many occasions, narrated about the incident of harassment, torture and assault meted by her in the house of the accused persons for non-payment of the rest dowry amount of rupees 5,000 family members of PW2. When this witness dispute the subsisting concerning the same, the deceased made her suicidal death in the house of the accused persons. PW 6 and 9 have also stated to some extent in the like manner in their 161 statement. These witnesses have resigned, but these learned session judges have referred to their 161 statement. Revealed further evidence of IO and confrontation up to the same.
Forget then 6 and 9 is no important.
Yes, no value. So then Then I am just taking up, then next page, a sum of rupees 5,000 is given at the time of Lagna and your lordships keep all these things and come to.
What do you want to say?
Yes, my lord, what he has done, your lordship kindly see. The last 5 lines I am reading, my lord. 3 to 161 result statement of PW 96 has brought IU has been established 3 to 4 months after the marriage. This is where Prabhati was subjected to cruelty by the accused persons and her husband and in-laws in their house, demanding rest, unpaid dowry rupees 5,000, as a result of which committed suicide within 7 years of marriage. Thus, my lord, last 4 lines of this. Thus, considering the above facts, proved fact, the statutory presumption arises under section 113A of the Indian Evidence Act, accused persons, so as to hold them liable under section 304B by chapter 4.
Yes.
For the said proved act. Hence,
It was held that it is suicidal death. So,
hence, the charge under section 304B is reduced to 306. Reduced to 306. And last paragraph.
is it your case that it should be 302, 304B only?
That should have been, well, they have been acquitted from that charge. And yeah, as your lordship, I was just going through a judgment, and your lordship, see paragraph 12. Consequently, the aforesaid analysis and discussion of the evidence on record, foregoing reason, the accused persons are not found guilty of the offences under section 304B, 302 by 34 IPC, acquitted from the said charges, and state has not preferred any appeal. My lord, your lordship, I have gone through a judgment of your lordships in 2024 that reported in SEC online, where your lordship has started with the Abraham Lincoln's quotation in a 306 case. Your lordship has held that in order to attract section 306, there is your lordship has analyzed that shui means self, side means killing, self-killing. For self-killing, there is also a offense under section 309 if the person survived attempting to commit suicide. And for 306, there must be an abatement under section 107. So, what is the abatement in this case, my lord?
Yes.
So, there cannot be any conviction under section 306. Only in case that for torture, they can be convicted under section 498.
498.
So, this is my only point. That is nothing else, my lord.
Yes, madam. It's a pure question of law he is raising. See, the trial court says that it is a suicidal death. No problem. It is a suicidal death. Suicidal death. And in the same time, 113 presumption, trial court says it operates. But having said that, he is acquitting in 304B. If 304B goes, only and convicted under 306. If 306 cannot be simpliciter be convicted unless there is an abatement. Where is the evidence of abatement? Because you have not challenged the acquittal under 304B. It is a case of 304B, clear-cut case of 304B. Because suicidal death is found on record and 113 presumption operates. So therefore, having noticed that, the trial court says that no, acquitted under 304B, but convicted under 306. If for bringing 306, the element of abatement has to be there. And there is no evidence of abatement. So therefore, he says, except section 4, nothing attracts. What is your answer to that? What do you want to show, doctor? Have you understood the question of law? Don't take me to the evidence. You answer this. Evidence is, he says, all evidence are correct, no problem. All evidence, he is not disputing the evidence. He is disputing this as part of it. You want to show me evidence? Also you can show. But that will be on facts. He is not disputing facts. Who is doctor according to you? Who is the doctor? 4. Read it if you want to. What will you get out? Yes. Read relevant part, I can't read it. Which part you want to rely? Vijay, hanging.
Yes.
There are two injuries also. Antepartum injuries. Have you explained it? Antepartum injuries in the body.
There are antepartum injuries, but I was acquitted from the charge under section 302. You were acquitted from the charge under section 302. So that is what I am saying, that this is a fit case where state ought to have filed an appeal. No appeal has been filed. After going through the judgment, the entire judgment is faulty. I don't know how he.
The external injury number 1 and 2 can be possible by fall over the blunt stone. The other injury is postmortem in nature. Yes. It is a case of 304B.
Yes, my lords. In item 33,
Yeah.
I have received the instructions. The appellant is no more, my lords.
No more. Good, good.
Here is the instruction that I have received. I'm passing it over to my lordship.
Mr. Rijvi, the counsel for the vigilance. The report submitted by so and so, so and so, so and so. As per the report, the sole appellant,
Yes, my lords.
the sole appellant K. Parameswar so and so, K. Parameswar Rao has expired on 25/9/2019. Therefore, the appeal stands abated in the absence of any application under section 394 CRPC by the LRs of the appellant or the next friend of the next friend.
Grateful.
Disposed.
That's another item is there at item 8. I have been told by my learned friend that it's in vigilance matter. Item 8. I was going through the orders that the orders were regarding to get the instruction regarding whereabouts.
8, eh?
Yes, my lords. But my lords, in fact, those orders were passed for the state council from the Advocate General's office. I was not aware.
Okay, okay. This the present matter is the state of Orissa is written so.
Yes,
the earlier order passed.
The order dated 17/7 and 2/9.
And whereabout of the appellant is directed to be obtained by the state council. Mr. Rijvi appears from the vigilance and submits that the orders, earlier orders, need modification to the extent that the direction should be which vigilance, which area?
My lord, I'm just going through the
Like it so and so.
We are not having
to obtain whereabout and so on so and time area. Okay. Okay.
In item
Vigilance-
number 16,
vigilance.
submitted the report.
Huh?
In item number 16, you submitted the report and they are alive. The appellant is alive.
16 and
16.
16.
16.
Alive, 16.
My
And
lord,
one more
no,
matter where
53
she was
is
appearing.
53 minutes. Sir.
No, 53 or so she was appearing. It was against the confiscation order.
53. Sorry.
Confiscation order, what is that? 53, no? No, Miss Dei was appearing, no?
In fact, my lords, there is another matter, item number 53.
Hmm.
It is CRL 84 of 2003. The appellant is very much alive, my lords, because my lords, if your lords see the order dated, the previous orders, my lords.
Alive, huh?
Alive, my lords.
Then it's
Can
ready
be-
for hearing.
Ready for hearing. Can I pray? Can we take it any other day? So grateful, my lords, so grateful.
You know, item number 6. It is sent submit the report. Appeal number 1 is alive, 2 and 3 is alive.
6, no?
Item 6.
My lords, in item 8, your lordship will be giving 3 weeks time to get the
3
values.
weeks time.
So grateful.
Give the SPs.
Barhampur.
SP Barampur.
SP Barhampur.
Barampur, vigilance SP Barampur.
My lords,
Vigilance SP.
grateful.
Art item 8, yeah. He was
No, item 6.
senior person, lawyer is appearing, yeah.
I was to buy somewhere. I don't 41. I'll be doing it. I'll put this one file in the original file and substitute.
From here it has gone somewhere.
If you have to buy the association or here. I don't care. Come after lunch, man, they sit and.
Okay. Yes. Anybody came in that?
My lord, my learned friend is appearing.
Acha, she is appearing. 30?
Hearing for this sub item in item
Right.
40.
40.
40. So what item? Yes, madam, are you ready?
My lord.
Okay.
My lord, against me, my lord, only circumstantial evidence. The gist of the case, my lord, the one Kalicharan,
Two people, two of you are convicted, huh?
my lord,
Separate appeals.
four persons faced trial, two convicted, two acquitted.
Two separate appeals were filed.
Two separate appeals in the same judgment.
Okay.
Against me, my lord, only, my lord, evidence, my lord, the confessional statement of the Kalicharan who was the co-appellant in another case.
Yes.
Here is the case, my lord. The informant is the PW1. Hollabag.
What is the prosecution story?
Prosecution story, my lord. my lord, undated 26/1/1994. My lord, the one Kalicharan, the co-convict, my lord, in another appeal, entered into the Port Malkhana.
Kalicharan is what? Working as?
No, my lord, is the
Outside,
outsider.
outside.
Outsider.
Okay.
My client is the working as a, my lord, Sirastadar at the time of occurrence.
Okay.
My lord, he was, my lord, inside the Malkhana, and the wife of the informant, my lord, saw the incident, and somebody entered inside the Malkhana and intimated the
Court Malkhana.
Court Malkhana.
Okay.
And the lock is intact.
Okay.
Tala bhanga bhangi kichhi nahi. Lock is intact. Thereafter, my lord, he intimated the bench clerk, and bench clerk, my lord, called the police team and rescued the Kalicharan. Thereafter, the present FIR.
Okay. What was stolen?
Nothing, my lord. Nothing stolen. କିଛି ଆଜ୍ଞା ହେଇନି, ସେ ଭିତରେ ଥିଲା, ମାନେ ନାଜରଠୁ ଚାବି ଆଣି ଖୋଲିଲେ।
What is 380 then? How 380, madam?
380 my lord made out ହଉନି ମୋ against ରେ। ମତେ କହୁଛନ୍ତି ଯେ ମୁଁ ଯେହେତୁ 26 ରେ on the day of my lord holiday, why my lord I enter inside the court Malkhana, enter inside the court premises.
Okay.
That is the my lord suspicious and adverse inference against me.
Okay. So let us read the evidence.
PW1 is the informant.
Nothing is stolen from the.
No, nothing, my lord.
They were cut there only.
Nothing has been stolen, my lord. I faced the trial, my lord, along with this offense, 20B NDPS Act. I acquitted, my lord, 20B NDPS Act. The allegations, my lord, my lord, the Kalicharan went inside the court Malkhana for stolen of ganja.
Ganja, okay.
My lord, I am reading the evidence.
Then how 20B is made out?
No, 20B
is no.
Prosecution charge has been framed. Charge has been framed. My lord, I faced the trial 20B. My lord, there is nothing is found. 20B, my lord.
Yes. Yes.
My lord, I am reading the deposition of PW1. I am working as a night watchman, Civil Court Samalpur for the last 3 years. I know the my lord, accused Daitarivat, who was working as a Nazir.
That is you.
And then Sirastadar of District Judge Samalpur. I know this accused, pointed out the accused Kalicharan, whom I saw for the first time on the date of occurrence when he was brought out from the District Judge Courts Malkhana. I do not know the other accused persons. 26/1/1994, the accused Daitarivat came to the District Judge office in the morning at about 6 to 7 a.m. and asked me to open his room and the English office as he would work. I opened the room and requested him to call me to lock the room. Again, when he would leave the office, opening the room directed by him, I came, my lord, thereafter, my lord, black from the upstairs and went to my quarters situated at, and thereafter, my lord,
back side of the
civil courts building. Then I sent my to market. When I returned at about 10 a.m. while returning, she passed by the Malkhana and then shouted at me. I came to her and asked as to what happened. She told me that someone was there inside the Malkhana, and though the Malkhana was locked from outside. We went near the door. She further told that someone inside the Malkhana was pushing and pulling, and Malkhana door kichu thila. I went to one side of the Malkhana and locked through the broken glass looped, looked through the broken glass of the window and saw someone was moving inside the bending position and trying to conceal himself. At that time, Doitaribek came out of the guest room, come inspection room, which was situated 7 to 8 feet away from the Malkhana room. He locked the door, the guest room, and out the key in his own pocket. I told him that someone was inside Malkhana. He pleaded that nobody was there, but only ghosts and witches were moving inside the room. Was weapons of offense used in different crimes were being kept inside the Malkhana. I protested and telling that I and my wife both have seen a persons moving inside the room. Then Daitaribag took our hands and gesture and appraisement and then protest before us and told to save him as we are all of one community. I did not agree and keeping my wife there went call the Nazir. Daitaribag was moving on the veranda when I to call the Nazir. The Nazir was found absent in his quarter. Then I went to the Pondababu, steno and register to told them everything and he told me, all right. In the office building and apprehending danger to her life, I returned to the civil courts building and found my wife sitting
Close to the Malkhana.
close to the
Malkhana.
Malkhana door holding the lock. Doitaribag asked me as to whom I met. I replied that I could only meet the Pondababu who is coming. At that time, Pondababu, the typist, Barik Babu arrived. Pondababu asked me to go to the upstairs. I went and opened the register's room. Pondababu made a phone call to CJM. Thereafter, SDJM arrived in the office room. CJM also arrived. Then both of them asked me as to whether that man was still there inside the Malkhana or not. I replied, telling that the said persons was there in the Malkhana. The CJM asked the Pondababu to take a phone call to the police stations. Accordingly, Pondababu made a phone call to the police arrived.
Yeah, I understood. Your conduct is suspicious. Yes.
Conduct, my lord, the learned trial court, my lord, adverse inference against me only, my lord, when I went to the court on the holiday. That is the one circumstances. Another circumstances.
But in the same time, you were pleading when with the.
My lord.
Yeah, please save
Yeah,
me.
in PW
I'm not involved and all.
PW5 is the wife of the PW1. My lord, your lordship kindly
Let's
see.
Yes.
The paper I get you together.
Within 5 months.
But I'm reading. I'm the wife of the informant. My husband
Read
serves
relevant-
as a night watchman in the court of district Sambalpur. District Sambalpur, when provided with the quarter inside the court premises just on the backside of the northeast. So and so I knew the accused Daitaribag
the middle is just 110. The accused Bagh Babu cut hold of my both legs
both legs
and
not to disclose.
saluted me and he requested me to allow him to so and so leg in the order to person inside the Malkhana to escape. I said, even if I could die, I will not allow.
my lord, the prosecution story, my lord, the lock is, my lord, intact, and the, my lord, key in the custody of the Nazir. That is the, my lord, my point, my lord. Suppose, my lord, somebody allow him to go inside. ଚାବିଟା ତା ପାଖରେ ଥିବ, ତାହେଲେ ଖୋଲିଲେ ହଁ ଚାବିଟା ବନ୍ଦ କରିବ, କିନ୍ତୁ ନାଜିର ଚାବି ଆଣିଲା PW10, ତାପରେ କବାଟ ଖୋଲିଲା. Your lordship, kindly visualize the
He
case.
was having another key with you.
No, lordship, that has not been seized. My lord, unless my lord seized the second key, my lord, how the court, my lord,
You didn't have a key.
no, lordship, that is my pleading. And my lord, since my lord, I have promoted from the Nazir to my lord Sirastadar, my lord, the other officials, my lord, against me, that is the my pleading, my lord, in the defense. For which, my lord, is both the persons, my lord, against me.
Then how the other accused, her client, enter inside?
My lord, that is the, my lord, unless and until, my lord, the second key has been, my lord, seized, or, my lord, against me, any evidence, my lord, I am talked of any connivance with the Kalicharan. Only the, my lord, PW1 and 5.
Is there anything coming, the Kalicharan entry into through some back door?
No, lord.
My lord, the informants, somebody banging on the door from the inside. Whereas they call the police, they call the SDGM and CGM, and in front of all these people, they rescue that person.
Kalicharan, they rescued you.
My lord. My lord, the keys were only supposed to be with a PW10.
So how you enter inside?
My lord. The
In
defense.
313, have you said anything?
Yes, my lord.
What have you said?
In 313, my lord, the appellant's plea is that.
Because if you are out, he is out.
Yes, my lord. My lord.
Because he is being implicated
On the
only on the ground that
confession that
he has allowed you to get
My-
inside.
My lord.
And for the purpose of allowing you to get inside,
My lord.
he should have another key.
Yes.
That respect is not coming forth.
My lord, if I may interrupt.
He was having another key, anything of that sort.
My lord, if I may interrupt my learned senior's
No, no,
argument,
no.
my lord, PW10 was the only person who was supposed to have the keys. The
Najib,
judgment
Najib.
also reflects that.
Najib.
Yes, my lord. And PW10 has not been examined. Nobody has asked him anything. And the judgment says, this is very speculative. When at page 58, my lord, page 39 of the judgment.
Please that.
My lord, when the Malkhana lock was opened with the key brought out from the Nizarat by PW10, none other than PW10 was in possession of the Malkhana key cannot be disbelieved. So only PW10 had the key.
Then how
Lord.
not broken?
The,
broken and
the-
there is no evidence to show that you have made a duplicate key.
My lord,
A duplicate
the
key
learned
is not seized.
goes on to say, since the confession made by accused Kalicharan before the witnesses cannot be disbelieved, accused Daitari Bag may not be in possession of any official key of the Malkhana lock, but he had opened the lock of the Malkhana and allowed accused Kalicharan
How has he opened?
to enter into it cannot be disbelieved. Furthermore, it is not very much difficult to prepare a duplicate key of any lock. Everything would have come to light had accused Daitari Bag remained present at the court premises when accused Kalicharan was rescued from the Malkhana.
That's a different story. He was present in the holiday, he was there and all. Unless something has come on record that he has prepared a duplicate, he was having a possession of a duplicate key
No key was
on the basis of which he has opened,
No, ma'am.
and you allowed you to go inside. Nothing is there.
There is no.
And rather in the contrary, the evidence is the only key is available with Nazir, that PW10.
My lord.
PW10.
My lord.
And the fact that he was rescued from inside, rescued or whatever,
In the presence.
then he has not stolen anything.
He hasn't stolen anything.
380. What is 380 then? It may be a case of trespass. Maybe a case of trespass.
My lord, even if it is trespass, my lord, he was inside and the door was locked. And the only person who could have locked it was PW10.
Oh, in 313.
My special knowledge, my
What
lord.
have you said in your 313? How you got inside?
He come to
So,
the 313 statement, my lord.
no, when it was asked, you were there.
80. Page number 80, my lord.
Yes.
My lord, have you, the question is, have you got anything to
Which
state
question,
about?
madam? Which question number?
At Page number 3 of the three.
Question number,
8, my lord.
yes.
8. Have you got anything to state about the witnesses and the case?
What does it
He
say?
says that
ସେଇଦିନ ମୁଁ
ଘରୁ ଟଙ୍କା ନେଇ ଆସିଥିଲି ମାଂସ ନେବା ପାଇଁ।
ମିନିଟରେ ଆସିଥିଲି ମାଂସ ଦେବା ପାଇଁ।
ମାଂସ ନେବା ପାଇଁ।
ନେବା ପାଇଁ।
ସେଦିନ ପୁଷ ପୂର୍ଣ୍ଣିମା ଥିଲା।
ମାଂସ ଦୋକାନରେ
ବ୍ୟାଗ ରଖି
ଦୋକାନୀ ପାନ ପାଇଁ
ଆସିଥିଲି।
ପାନ ପାଇଁ
ଯାଇଥିଲି।
କୋର୍ଟ ପାଚେରୀ ଭିତରେ ପଶିବା ପରିସ୍ରା କରିବା ସମୟରେ ଜଣେ ଧୋତି ପିନ୍ଧା ବୁଢା ମତେ
ହିସାବ କରିବା
ପାଇଁ କୋର୍ଟ ପିଣ୍ଡାକୁ ନେଲା। ତାପରେ ଜଣେ ବୁଢୀ ଓ ଜଣେ ପିଲା ଉକ୍ତ ବୁଢା ଓ ଅନ୍ୟ 2 ଜଣ ଏପରି 5 ଜଣ ଲୋକ ମତେ ଯାଇକରି ମୋର ମୁହଁରେ ଗୋଟେ କପଡା ପିନ୍ଧାଇ ଦେଲେ ଓ ତାପରେ ଗୋଟେ
କପଡା ପିନ୍ଧାଇ ଦେଲେ। ସେ କପଡାରେ ଗୋଟେ ଗନ୍ଧ ହେଉଥିଲା। ମୋର ହୋସ ଉଡିଗଲା। ମୋର ହୋସ ଆସିଲା ବେଳେ
ମୁଁ ଗୋଟେ ଅନ୍ଧାର କୋଠି ଭିତରେ ଅଛି।
କୋଠି ଭିତରେ କେମିତି ଗଲା?
My lord, he says that
ମୁଁ କବାଟ ପିଟିଲି ଖୋଲ ଖୋଲ ବୋଲି ଡାକିଲି। ତାପରେ ପୋଲିସ ଆସିଲା ପରେ ମୋ ନିର୍ଦ୍ଦୋଷ କଣ ପାଇଁ ମୋ ବିରୁଦ୍ଧରେ
he says that the one old man called him and 5 people were there. They blindfolded him and put him inside the room.
I admit it sounds very outlandish, but my lord, if I may please read the witnesses who have supported this exact thing.
I hear you. But this is very funny case.
Yes, my lord, he says that he set out from his house to buy meat and kept his bag at the meat shop, went to a pan shop, and somebody called him from there in order to ask for some hisab or something, and he had gone, in fact he had gone to urinate inside the court premises because we're right in front of the pan shop. And then he somebody calls him and they literally put something on his face and abduct him and take him inside, and when he gets up he finds that he's inside the malkhana, and then he bangs on the door, please rescue me. This has been witnessed by the informant's wife who found him there, that some banging sound was coming from the inside. He says that when I came to my senses, I frantically banged on the door. My lord,
but the fact that you were there, that is not disputed. How you went is a very strange thing. The strange story somebody has taken it.
Lord, if I broke into the house, my lord, then I couldn't have locked
At least that could be a case of 454.
My lord,
454. 380 is not.
locked myself from the outside, which is a very strange fact that is coming out here.
You are right there.
The malkhana door was locked from the outside.
Trespass means you should have gone inside, but it was locked from outside.
Yes, my lord. And nobody claims that they had locked me in order to confine me. Nobody says that. I was found inside the malkhana door. That is being said.
Yes, how will you explain all
Your
this?
Lordship, I am placing the deposition of the PW9 and 10. PW9, who is
Now, what are you trying to
he has
bring?
clearly stated that the appellant number Daitari Bag, who was the one, he had supposed to have 2 keys. He have hand over to 1 keys to his successor.
And retain 1 key with him.
Another key is not been supplied to the successor, keeping to him. And the PW10, who has clearly deposed before the court, he has identified and on the very fateful day, he was came inside from this malkhana house, Your Lordship. That not been
Has he seen it?
Yes, I have. Your Lordship, that is PW running page. Your
The
Lordship.
second key was seized.
No key was seized.
Lordship, there is 2 keys, Your Lordship, usually. Only here the Daitari Bag, who is the predecessor of the PW10, has only given the charge of the 1 key of that malkhana. But so far.
Therefore, you presume that the other
No,
key must be there with you.
I'm not presuming, and also has clearly deposed that on the inside room, the Kolahaki person, Kalichरण Bag, who was outside from the Malkhana lottery. And
No, no. Have you seized that one key which was there with him, which supposed to have been used?
that
Because
particular,
from the spot you have arrested them.
That's it.
The key must be there. Either the Daitari or obviously with Daitari.
That's it.
You have arrested them from spot.
That's it.
What have you recovered from them? Where is that key?
Though the Malkhana is outside the lock, by breaking the window, he has entered inside the Malkhana house and bring the ganja box towards the gate, your lordship, in order to pass the Malkhana house, your lordship. That is their statement of the lordship, PW10.
My lord,
But still I am asking one question.
Lordship.
If the key was there with him, second key, he might have opened and allowed him and locked it from his side. Saying that you arrange everything, I'll open it, it'll go. That was the case. You apprehended them there only. Nazir was called by PW1 and his wife and apprehended. If you have apprehended from the spot, have you not recovered the duplicate key? And 380 for theft, he was inside the room. He was rather rescued by opening the door. So there is no theft at all. It will be maybe an attempt or whatever. And what she now is saying, 454 is also not made out because I was inside. I was locked. Then how will you bring 380 and 454?
That part I will satisfy. After lunch,
You tell me after lunch I'll hear. Continue. Yes, yes. 56. Which year?
My lords, I'm extremely sorry, my lords. Instead of item 8, I was told that item 8 is a vigilance case. Instead, it is item 9, ma'am. So the order passed in item 8 may be passed in item 9.
Item 8 is the order passed, na? Item 9 is.
item, my lord, in item 9, I may be allowed to take the TCR, my lord.
Item 9?
Item 9.
He died, I think. Item 9 died, na?
My lord, that item which I was mentioning.
What?
My lords have directed the State Council to seek
Ah,
instruction.
Let me wherever to come. Huh?
My
You can take it from. I'll continue with this.
lords.
Yes. Yes. Yes.
Lordship, so far there are two appeals, two appellant is there. There Doitari Bag is appellant number, appeal number 15898. And Kalichana Burma is 15498. I am segregating, first I am confined to Kalichana Burma. Appeal number 15498. What is the materials against the Kalichana Burma? I would like to satisfy to Lordship whether
Yes.
454 and 380 is made out, well made out against the present appellant or not. Before going to the Lordship, I am reading the 380 also. What says 380, ingredients of the 380 also. Theft in dwelling house it is. Whoever commits theft in any building, tent or vessel, which building, tent or vessel is used as a human dwelling, comma, or used for the custody of a property. Here, I am repeating, here the Malkhana is the custody of the property also. And the present appellant accused very much arrested from the spot.
This is read 378. Read 378.
Yes.
Come to the definition.
Definition. I am coming.
Ready.
Yes. Whoever intending to take dishonestly any movable property out of the possession of any person without that person's consent moves that property in order to such taking in said to commit theft. Movable property also. Here is the saying that defines the dishonest and movable property also. My respected submission also, the Malkhana is meant for the keeping the valuable articles, seized articles of the court premises, the public is a
Has the appellant has moved this property from that place to his position?
In what happened in Malkhana, there is two rooms, inspection room and Malkhana room also. The present appellant, Kalichana Burma, who had by breaking the tin, which is kept in by seal, by breaking the tin, remove the articles kept in the Malkhana door in order to pass the Malkhana door. Lordship, then is a clear case of in order to pass the articles, he is kept inside the door premises. So 380 is concerned, the Lordship clearly made out in the Kalichana Burma. And in order to supporting my arguments, I am placing the evidence led by the PW 9, 10, and 11, who were the material witness who has clearly stated the role and played by the present appellant number Kalichana Burma.
Yes.
I am placing I am placing in order to substantiate the materials against the Kalichana Burma. I am placing the evidence of the PW 11, who was the Lordship
PW
11, Lordship.
You are relying on PW line 9.
Again, Your Lordship?
PW 9.
I am placing 9, 10, and 11, Your Lordship. And so, yes, Lordship. PW 9 is the who is the Lordship, the Malkhana guard, Your Lordship.
Read it. Which part?
I am placing the second, Your Lordship, holding paper books, Your Lordship, page 133, Your Lordship.
133.
Lordship. Placing PW 10, Your Lordship.
9, I am talking about 9.
Yes, Lordship.
Read first 9.
Sorry. I am coming there. Lordship, that is the page 125, Your Lordship. Page 125 of the paper books, Your Lordship.
Yes. Which part?
The first part is the middle portion, Lordship. 10 lines from the bottom, Your Lordship.
I saw this.
Yes, I had also seen Dara Singh, the sweeper of the court. I had also seen Bhodabag and his wife and the Mazir Kesab Bade also arrived there. A group of people also standing there. I saw also Raghav Babu identified to Doitari Bag in dock was standing inside the veranda of the court building. Lordship, thereafter, that in next page 126, Lordship, that in paragraph 2, and so first I am placing the from the top of the, at about 4:30 to 5 p.m. Badhi Babu, the present Nazir arrived there. The CGM was in charge of the registers. He, as well as the register SDGM who was in charge of the register, also arrived there. Police persons had already arrived. Nazir Badhi Babu opened the lock of the Nazir Khana and brought out of the key of the Sessions Court Malkhana and opened the door of the Sessions Court Malkhana. When the door was opened, I saw the ganja lie after layer was kept in the entrance door of the Sessions Malkhana. That I also accused Burma, the cultural Burma, who is the accused Kaljan Burma, identified to the accused Kaljan Burma, the said Malkhana. I saw that the seal of the boxes had been opened. The materials which was kept in the Malkhana was broken. I also saw some of the leaves, that is mango, that is not, I am not, Lordship, Director, Lordship. The lock of the inspection room there.
Thereafter, the accused Burma was brought out
Lordship.
from the Malkhana.
Yes, sir.
And was taken towards the inspection room of the court.
Lordship.
The lock of the inspection room was lying opened. I saw the
dragging mark of some bags from the Malkhana up to that inspection room. I also saw 2 bags containing ganja in that inspection room also.
Yes.
And that also, that evidence of the PW9, though the cross-section not been discarded, that as good as the solid piece of evidence in order to bring home these charges 380 and 450 against the Kalicharana Burma.
Yes.
May I proceed to another appellant?
Yes.
And 10 is also incorporated the evidence of the PW9. 10 and 11 is clearly stated the present appellant number Kalicharana Burma complied with the present appellant Kalicharana Burma also. Then, Lordship, I am placing the PW10, Lordship.
Yes.
I am placing PW10, Lordship. I know I am placing from the beginning so that it is consecutively come to the notice that what the involvement of the present appellants also. I know all the
9, let us complete 9.
Okay.
Come to 5.
Per question party, Lordship.
Nazir Babu.
I have read, I know the English, I think slightly. I read.
No. Annex 128, page 128, para 5.
Lordship. I don't know, remember that party, Lordship. I don't remember the
Nazir Babu brought the key.
Nazir Babu brought out the key and handed over to me and directed me to open the lock of the Malkhana.
The accused was inside the Malkhana.
I opened it. I accused was inside the Malkhana at the extreme corner whereas ganja was lying by the side of the entrance door, Your Lordship. Police people focused the torch to the Malkhana. Electric bulb was not burning. The Malkhana was full of dirt. Sorry. I don't remember if Kalicharana was wearing a chappal or so, or he has in barefoot. I have not seen any footprints inside the Malkhana by the side of the dragging mark of the bag. Police had not examined the nails to detect any remnants of the jute. The ganja were brought out from the Malkhana and thereafter the same was seized. Police staff brought out the ganja from the Malkhana to outside. Ganja were seized from the Malkhana. Some ganjas were lying open where some ganja were inside the tin box. There will be 3 boxes inside the Malkhana, out of which the seal of the 2 boxes had been opened. Police also seized the lock which had been used in sealing the boxes. Some papers were pasted in those tin boxes where the case number has been noted. I cannot say the case number noted in each those paper slip. no lock were lying in those boxes. The hook of the boxes had been tied by the thread and those had been sealed. I had given the 3 signatures on 3 scissor list. Police had not taken my signature on any of the papers apart from the scissor list. Police had never taken my signature on any paper and had never pasted them on the seal box. Police people brought out the weighting scale in which ganja were weighted. Next para, I will say. I knew what is the ganja earlier. Police had not examined me and not recorded my statement. It is not a fact that I was examined by the police, that my statements was recorded by him. After the date of incident, for the first time, I am stating about the facts about the date in court today. It is not a fact that I have not seen anything and that I don't know anything about this case and that I am deposing falsehood being the staff of the court. It is not a fact that my signature were taken not at the court premises and that they were taken later on at the instance of the police. Then proceed on the side of the accused appellant, the theory by your also.
The inspection room was open.
That's it.
Huh? PW9 says the inspection room was open.
So far, I have seen in the Malkhana also. One entrance, inspection room is first, there is the Malkhana also. Usually.
Inspection room was locked or not?
Locked.
Inspection room was also locked.
Usually keeping in lock mode, but in that case it's broken. In here is the case is here also.
Inspection room door was blocked, broken. PW8 what? PW9 what he says? It was open.
Open.
It was inspection room was open.
Yes.
That's what he said. Come to PW10.
Lordship.
133.
Lordship.
In between. The inspection room was under lock at that time. Though the window was seen that 2 bags were lying inside the inspection room, by then the key that the inspection room was with accused. The Terry bag. Inspection room was under the lock and key of the Terry. But 9 says that it was open.
That is there.
9 says open, 10 says broken.
And the informant and his wife also say that he had taken the keys from them.
Sorry?
The informant and his wife also say that he had taken the keys from him, asking them for the keys in that very morning. That I have work, I have to go to the inspection room. So that is contradictory everywhere.
Uh, 133.
Read further.
Yes.
If you read 133.
Yes.
Prior to my arrival,
Yes, in your
the Terry bag had already left the court premises. Thereafter, the lock of the inspection room was broken. Those bags were containing 10 packets of ganja each and 5 packets. On the weight, 10 packets containing so and so. If your case is from Malkhana, it was displaced to inspection room. Both inspection room was also closed. Through window, that's what you said. Through window, it was thrown to inspection room.
I am placing this one the PW statement of the PW 10, page 133 also. I am placing slowly also. From the police and the 133 top two lines after the police entered into the Malkhana and brought out black complex person witnesses and show Kalicharana Burma in doubt. On question with them, disclose his name Kalicharana Burma, and in order to commit the theft of ganja, he entered inside the Malkhana. The ganja in 4 bundles were seen kept inside the Malkhana near the entrance door. The papers of the 2 tin boxes had been broken. It was also seen that the dragging mark of the box was lying up from the Malkhana up to the inspection room. Lordship, inspection room of Malkhana, one door, there is 2 rooms. Though the inspection room was under lock at that time, through the windows, it was seen that 2 bags were lying inside that inspection room. That is there, Lordship.
Spot map. No. Spot map, no.
May I read you also placing them. The paper seal of the 2 tin boxes had been broken. It was also seen that the dragging mark of the bags was lying from the Malkhana up to the inspection room. The inspection room was under lock at that time. Though through the windows, it was seen that 2 bags were lying inside that inspection room. See, again, out say PW paragraph cross examination से कहते हैं जो चाबीटा किना जाए usually 2 double चाबी रे किना जाए double चाबी दिया जाए रखे आप that is there 135 page रे अच्छी से गोटे चाबी while handing over the charges he has given the charges only 1 key of each rooms each lock each locks.
But he explains that when he received, he took over the charges on 20th December 1993, 1 key was given. That was entered in a khata. Where is that khata? Have you
seized by the police?
Where is that? What have you exhibited that?
My lord, DW2 was the his predecessor. PW10's predecessor, and sorry, my lord.
Yes, what he says.
He says that I was given 1 key each. Therefore, I had handed over 1 key each. My lord, that has been reflected in the judgment also.
My lord and sister will be placed his evidence in supporting his claim, her claim. ମୁଁ ଟିକେ କହି ସାରେ ମୁଁ ତ 80 କି 454 ମେଡ୍ ଆଉଟ୍ କରି ସାରେ ତାପରେ
yes
ତାପରେ ଡିସକାର୍ଡ କରିବେ କୋଉଠି ଅଛି
DW1 DW1 you said no? Yes yes
Basudev Panda.
Lordship, I am placing the 133 page, Lordship. Though the windows, it was seen that 2 bags were lying inside that inspection room. By then, the key of that inspection room was with accused Doitari Bagh, who was the ex-Nazir. Prior to my arrival, Doitari Bagh had already...
What are you trying to get out of this?
I am bringing to the charges so far 380 and 454 is concerned.
From this witness, what are you want to show?
So far, Kalicharana Burma is well made out. So far, inside the room while breaking the door has come to the police. So far, Doitari Bagh is concerned. Doitari Bagh.
How it is made out against Kalicharan?
Kalicharan, Lordship.
380, how it is made out?
380, Lordship, is clearly says, Lordship.
What are the ingredients of 380?
380, Lordship, clearly says who commits the theft in building a land or vessel which building or land used to as a human dwelling house or used for a custody of a property.
So he has not taken into custody.
Again, trying to keep the door in at the entrance part of the Malkhana, Lordship.
It could be. See, you should have been endeavored to show.
What is the intention you need to keep the ganja inside keeping in the entrance point in order to pass over the mat says contaminated ganja to out from the Malkhana, Lordship. That is the reason.
Yes.
That's it. The inspection was lying accused Daitaribag, who was the ex-Nazir. Prior to my arrival, Daitaribag had already left the court premises. Thereafter, the lock of the inspection room was broken. Those bags were containing 10 packets of ganja, each of the 5 containing packets. On waiting, those 10 packets came to 28 kg, that is 14 kg, 5 bags containing 1 bag, and 14 kg for another 5 bags containing 1 bag. Police seized those 2 bags containing 10 packets of ganja and prepared the list. Exhibit to the so far. 4 packets of ganja lying near the entrance door of the Malkhana were seized by the police in my presence, and seizure list was prepared in which I signed, and wetman those were packets came to 9 kg. Exhibit police also seized the 2 tin boxes which are lying under the seal, but the seal had been broken and had been broken. Prepared seizure list exhibit 3. And my signature is exhibit 3 by 3. Metal MOs 1 and 2 are the seizure boxes. The contain the seized ganja packets. All the seized article, that is the 2 tin boxes, MOs 1 and 2, 37 kg of ganja and ganja packets were given to me in Jima. Signed in the Jimanama, which is exhibit 5, and my signature on it is exhibit 5 by 1. A khata had been prepared to enter the articles of the Malkhana taken from the Nazir. Accused Daitaribag in charge. The taking of the charge started from 2012 to 1993. The court Malkhana consists of 2 rooms which were locked by 1 lock each. Daitaribag had given me charge of 1 key for each lock. I am emphasizing, Your Lordship. Daitaribag had given my Lordship 1 key from each lock. When I demanded 2 more keys, he said that he had taken charge from his predecessor only 2 keys for 2 locks. That khata showing taking over the charge of the valuables is with me. The tin boxes had contained ganja seed in connection with the so and so case. On paragraph 3, on 2494, accused Daitaribag had brought 1 door screen from the Chowkidar, Ugres and Behra, just 2 days before, Your Lordship. It's 26th when the incident was happened, and was sleeping in the inspection room. Your Lordship, kindly, that part, Your Lordship. We suspected that they might be involved in this case. During inventory into the court Malkhana, it was noticed that 3 bags containing ganja, weighing 16 kg and 22 kg, and 30 kg 500 grams from the boxes were missing, and they had been kept inside the Malkhana in connection with that is there, Your Lordship. And my 135 page, Your Lordship, can glance from it. Proceeding from the Kalicharan Burma, paragraph 4 of the last part, 5 to 7 lines, 6 lines, Your Lordship.
The cross-examination, 135, the police
police,
did not seized the copy of the valuable register mentioned by me after taking of the charge of the articles from the ex-Nazir. 135 mid portion.
Me pressing the 135 page, Your Lordship. Proceeding paragraph 4, the last 5 to 6 lines very relevant. You know, to come to that, there is 2 keys, Your Lordship, from the each lock. My pressing.
Which one?
135 page, your lordship, proceeding part of the.
I read it already.
The two keys, your lordship. And
But
there are paragraph 5. Lordship.
See, he says that the one key was given by his predecessor. That is entry in the khata. That is not seized by you. DW says that DW is the person who has given the charge to him. He says that one key is given. How will you? And he says I suspect it may be.
Lordship. Might be one key and over. My what cannot be duplicated, your lordship. I am not. Though there is no material so far as so is concerned. I am only.
Then I will presume that
no, lordship, clean sheet material. So far the entry into the Malkana.
Remember you are arguing a criminal appeal. Show the evidence.
No, I am not.
Show the evidence. This might have happened. That might have happened. So many things might have happened.
My lord, in that case, why the defense did not help?
I'm still struggling to find out something in your favor. I'm struggling here to get you. I have already reached.
In the prosecution.
PW1 I have already reached. 11.
11. Yes, your lordship. I am.
You show me.
Yes, your lordship.
You have to prove the case beyond all reasonable doubt.
Beyond all reasonable doubt, I am also that keep in mind, your lordship. I am paragraph 3, your lordship, page 140, your lordship.
Enter into the Malkana and by that time 100 persons.
बाहर घर हो गए 26 जनवरी 26 दिन थिला से दिन जेहेतु फ्लैग टेस्टिंग थिला से इंसिडेंट हला वेरी गैदरिंग है दैट डजंट मीन द लॉर्डशिप इनसाइड रूम से पुलिस अरेस्ट करछि एंड द मेटल सील box has been broken and materials has been to pass the materials from Malkana has and turning to get more which in the lordship.
$140.
That's it.
Para 3.
Lordship. Though thereafter we asked the Kalichona, sir, your lordship, that para your lordship, as to why and how entered into the court Malkana, he replied that Raghababu had allowed him to enter in the Malkana to bring ganja from the said Malkana. Thereafter, we noticed that the door of the inspection room was simply closed, but it was not locked. I noticed also some dragging mark from Malkana to the inspection room. Thereafter, I noticed some packets in the inspection room. I have also noticed some of the ganja leaving open.
The inspection room was open, according to me.
I have also noticed some of ganja lying been inside the Malkana near the entrance door. And thereafter, police took the accused as well as the ganja packets to the PS. Thereafter, I left the court premises and I didn't know what happened.
Yes.
PW12 also.
Who is PW12?
Who is the stenographer in civil court? At that point of he was
Register,
civil court. Registered with the civil court option.
In spot map not filed by the prosecution. Though they have said 2 rooms, so and so, spot map has not been filed by the prosecution in this case.
144, your lordship, that is the PW 12, who is the steno to the registered civil court, your lordship.
ये for one.
My lord.
Yes. Anything?
In support to my case, I am placing the PW, emphasizing this evidence of the PW 9, 10, 11, and 12, and show the seizure list of the seized metals, and that the present appellant is the offense under section 380 and 454 is clearly made out, and that evidence led by the trial court not been discarded in the prosecution. That is my submission, Lordship.
What is the reasoning by High?
Lordship, that is paragraph, Lordship, in the judgment. The paragraph, page 59, paragraph 11, Your Lordship. Yeah.
44 page. Last paragraph.
May I read it also?
Page 44, last 5-6 line. I feel seizure of those ganja in Malkhana and the inspection room cannot be treated to be the seizure of ganja from the conscious position of the accused. As admittedly, they have not been seized from the possession of any of the accused persons. And furthermore, the Malkhana and the inspection room belongs to the district and sessions judge, and the ganja seized was involved in the investigation also, was kept in Malkhana. Furthermore, the material, the mandatory provision under NDPS Act so and so is not complied. Admittedly, the accused Daitaribaga was not present at the spot when the LA seizure was made. That being so, I feel the accused Kalicharan and Daitaribaga cannot be held guilty for offence under section 20B of NDPS Act. And such they are acquitted also.
20B.
They are acquitted.
20B, so
Fine.
20B is concerned.
No, that's not important. Important is court has said there is no possession.
Exclusive position of, in order to attract the section 20B of the
No,
NDPS.
forget about in order. There is no possession. That's the finding.
That is
If there is no possession, where is the question of 380?
What here is the present case, this charge from 20B and other IPC offence also. So for 20B is concerned, therefore the conscious exclusive person is not been detected.
Do you still think that I have not understood?
No, I
They
am
have
not saying.
preferred any appeal.
You have not challenged that part of the finding.
Finding.
That part of the finding you have not chosen. And the court says that the possession cannot be believed.
So, but
if the possession of the ganja, see, your case is they enter into the Malkhana with an object to steal the ganja. And the court, by appreciating the evidence of 9, 10, 11, and 12, have come to the conclusion that the possession of ganja is not to be believed. This is one finding. Second finding is they have not shifted it because they were found there inside the Malkhana only. Rather, it was locked from outside. Then how will you bring theft? What was theft then?
Lordship, so far 370 theft is defined, Your Lordship.
What does it say?
Theft, whoever intending
Hmm.
to take disinfected any movable property out of the possession of any person. Lordship, what happened?
That's what I'm saying.
Lordship, possession means that is the ganja, contaminated ganja is meant for in the inside the malkhana, not in the entrance part of the malkhana room. The person, the appellant entered in the inside and displaced from the exact position to in your to.
Where is the map? Where is the map? You show me.
It has not been proved sufficiently.
Where was the ganja was there? How it was displaced? And it was displaced for the purpose of taking it out. Where is the evidence?
And breaking.
Where is the evidence? Show me. Don't analyze things. Don't read in between. You have to tell me the exact evidence. Have you suggested to these witnesses anywhere saying that the ganja was shifted from X place to Y place inside the room? Suppose this is the malkhana. How the accused has entered into, nobody knows. It was locked from inside. The ganja is here. He has shifted the ganja there.
Lordship. Dragging marks is there.
Dragging mark, everything is there, shifted there.
Yes, that
he has not
370
removed. He has not removed it. And in the face of this, if there is a finding that the position he has not taken into the position of those articles, then how 380 is made of?
Shifting, Lordship, 370 part, Lordship, theft is defined, Lordship.
I think you are not able to catch what I'm saying.
Yes, I am already, Your Lordship, I have understood the contents, Lordship. But dragging mark is there. And the article which was meant for in the inside the costume.
That was not believed by the court. I was wondering whether NDPS Act for non-compliance of 52, 57 and all, they've been acquitted. No, the finding is possession was not there with them. In Daiter is concerned, he was not there at all. He was not at the spot. Only the Kalicharan was there. The possession of the ganja is not believed by the court. Therefore, acquitted. And you have not challenged that.
Very bad is concerned, I am replacing the exhibit 6 also. Exhibit 6 is 162 statement of the Kalicharan Dehuri's mother. She has clearly deposed on the very fateful day. Court staff asithile misiki gale.
My lord, in her testimony, she has rejected that.
Exhibit 6 also. It is a 162 statement of the mother of the main principal like Kalicharan Burma. On very fateful day, court staff, court staff as the Sanghi Jachan. The Vitari bag is allowed to enter the inside room by keeping in the key of their malkhana. That is the crux of the matter also.
My lord, here I beg permission to interrupt.
Yes, I'll give you one.
My lord.
Gopal Pradhan or Sunil Mishra acquitted.
Hmm?
Gopal Pradhan and Sunil Mishra.
Because 201 is not believed, 201 acquitted. So therefore, all of them are acquitted. Para 48 region, para 10. Page 48, para 10. Accused Daitari Baga had entered into the Malkhana for committing theft of ganja and with the help sifted the ganja from Malkhana to inspection room and dragging mark bag from the Malkhana to the inspection room, having been noticed by so and so. The ganja having been seized in the Malkhana at the entrance gate too, as well as from the inspection room. The parents of Piro so and so. Presence of the 30 in the court premises on a holiday, requesting Piro who is allowed. So there are the two things. One is the dragging marks are there and the ganja was lying in the entrance gate.
Entrance.
These are the two things on the basis of which the court says that no.
In the absence of spot mail, my submissions, my lord, in the absence of spot mail, only, my lord, of the evidence of
again
the.
speculating. It is again speculating.
Quorum thila, no spot map has not been filed.
Where was see
Everyone was deposed at.
how these two rooms, Malkhana and inspection room, are situated is not coming clearly on record. It is adjacent to each other or from inside the Malkhana. It was one of the room inside Malkhana. How will I know? The court only says that there were dragging marks of the tin box from the Malkhana to the inspection room. Dragging marks of bags. And two bags were thrown inside the inspection room. That's what the case is. And inspection room key was with Daitari, that is your client. So the prosecution story is Daitari allowed Kalicharan to get inside the Malkhana with an instruction that you shift it to the inspection room. The inspection room will be opened by you and the ganja will be taken out. That was the plan. That was the
One witness says that is broken and another witness says, my lord, it is open. It was open.
Which one? The
PW9 says,
inspection room. Inspection.
the PW10 says it was broken.
Inspection room.
Inspection room.
That is, in addition to my learned senior submission, I will, the incident is in 94.
You people have very no, these people have very tactfully done it. You have done it. There is no doubt about it. You have done it. The problem is I am finding out where is the evidence. You have done it.
My lord.
That's for sure. That's for sure. But the problem is there is gap. In the evidence there is gap. How much you have undergone, by the way?
My lord, the appellant, my lord, arrested on 28/1/94. 28/1/1994.
94 and
released on bail by the order dated 2/3/1994, passed by the learned sessions of Sambalpur. এটা হাইকোর্ট ରୁ বেল ଯାଇଛନ୍ତି କିନ୍ତୁ ଏଇଥିରେ 272 of 1994. I verified the
okay, then you have undergone about 2 months, 3 months. No, 2 months.
2 months.
2 months.
28 करू.
My lord,
And what about after conviction?
After conviction,
389 benefit you. What is the sentence here?
5 years, my lord, for the offense under
380.
380 and 2 years
For 454.
454.
3 years, 454.
5 years for 380, 2 years for 450.
2 years for 450.
Yes.
The co-appellant is perhaps he had.
Yes.
The co-appellant was perhaps in custody for more than 4.5 years.
More than?
I'm not 100%.
Find out from here. The same thing. You could find you see in so far as in appeal number
158, my lord, I am appearing for the
no, 1 through 1
58 of
158 of
1998.
8. Okay. 158. This is the period undergone. You tell me, ma'am. Almost
More than 4 years perhaps.
more than
During trial, he even custody.
Custody throughout.
54 of
PD has more years.
1998. Undergone period you tell.
My lord?
Period undergone you tell, and both of you file your written note of submission. Argument
Next, by
both the parties are file written note of submission within a period of
within 7 days, your lordship.
Huh?
Within 7 days.
2 weeks.
Your lordship.
2 weeks, my lord, better.
2 weeks. Yes.
Second of the, my lord, puja vacation.
I know.
So many
Therefore,
works.
2 weeks.
2 weeks.
2 weeks, huh? Therefore, 2 weeks. 1 year, 2 weeks. And give your appearance.
May be allowed to submit, my lord.
Yes, yes.
My lord, if I may be allowed to submit orally, little bit, my lord.
What do you want?
My lord, the case, the conviction has been based on basically 3 things. Extrajudicial confession, as they call it, that he had confessed before with PWs 9, 10, 11, and 12. That is admitted that he might have confessed, but my lord, it was throughout all the confessions were before direct presence of the police, my lord. So it is directly hit by Section 25 of the Indian Evidence Act. Police was throughout there, my lord. They had rescued him and throughout he was there.
Evidence.
Confessional statement before the police.
My lord, he has also been arraigned as an accused only because of my confession. And my confession was before the police. I was
But
directly.
how to get out of 9, 10, and 11, 12?
My lord, they were there and the police was also there, my lord. The police rescued me and took me into custody.
These people have made statement on 161.
My lord, the same confession about this. No, 160. My lord, the confession was before the officials as well as the police. I was never beyond the presence of the police.
So
throughout.
you give concession to that confession lead confession.
My lord, the
But
second,
independent witnesses were there.
uh,
8, 9, 10, 11, 12.
along with the police, my lord, they are also.
Maybe because obviously their statement will be recorded by police only. How it 25 hits?
Because it is.
25 will not come.
He was in the custody of the police, my lord. The section states that he.
So had it been a case that entire conviction is based on your confessional statement, one can understand.
My lord, throughout the judgment also that has been reflected repeatedly that on the basis of my confession, I was also implicated and the co-appellant was also implicated.
But all the other witnesses were there present.
My lord, other
Court staff and everybody was
court staff were there. Well, the second thing, my lord.
They were there.
And my lord,
The trial court has taken the confessional statement very seriously.
Very seriously.
But that can be given, a go by. That's not a important
And
thing.
also, the trial court has given a lot of importance to the 164 statement of the mother of the accused, this appellant. My lord, the trial court has said it is an important piece of documentary evidence. I beg to submit that it is not a piece of documentary evidence. It can only be used to corroborate or contradict the testimony. And in her testimony, she has gone hostile and she has said that I never said those things. And she has totally supported the defense case, my lord.
So PW?
PW6, my lord.
Secrecy 164 report the
But she in the witness box she is not supporting.
hostile
My submission is that it can be used, 164 such statement can be used to discredit her testimony or maybe even prosecute her for perjury, but it cannot be used to convict
Someone.
my lord.
You are right, absolutely.
And my lord, the third thing, the
This is
presence.
the proposition of law.
Yes, my
You
lord,
can very-
presence of the accused, which I am unable to. My lord, there also, my lord, if 2 minutes are allowed, I will.
Yes, please.
My lord.
Tell. I have read everything. Because
My lord, I already placed the 313 statement of the accused, wherein he has given a.
He has given a plausible defense. How he has entered inside this Malkhana.
My lord, and that has been supported by my lord DW.
2.
PW
PW2 is the key that.
My lord, PW13, 2 prosecution witnesses and 1 defense witness, my lord. First of all, the story starts with PW6 itself.
He's trying something. Yes. I'll just hear he's trying.
PW6 says, sorry, my lord.
It's all right. No. You must do it.
My lord, para 3, page number 117.
Careful. Yes. PW 13 you are talking.
No, my lord, 6. The mother of the.
Yes.
My lord, it is a fact that my son is suffering from heart problems and unable to take up strenuous work. It is a fact that my husband is also suffering from rheumatism and unable to walk properly. It is a fact that on 26/1/94 at about 10:30 a.m. I had paid ₹60 with a bag to my son Prasanta, alias Kalicharan, for purchasing of meat. It is a fact that the police did not tell me about that bag and cash of ₹50. My lord, only this much. Lord, now coming to witness PW13, my lord.
Yes.
PW13, my lord, again para 3 cross-examination, page 151.
Yes.
My lord.
I know the accused.
I knew the accused Kalicharan Verma as he was coming to my meat shop to take meat. On 26/1/94, I had come to my shop at about such and such. At that time, accused Kalicharan had come to my shop, took meat, and about 10 to 15 minutes thereafter, he left my shop.
Then your defense story is being supported by this.
My lord, by the prosecution witnesses until now.
Yes.
Now, my lord, coming to DW1.
In the meantime, you met with his client, it seems. Then you passed you planned everything, you went there.
My lord,
Instead of,
I cannot concede officially, my lord.
anyways, lighter side, I'm telling you. Yes.
My lord, deposition of witness number 1 for the
Then you
defense.
say PW, 1 minute. P 313, 313, PW6,
6, my lord.
PW6, PW13.
My lord.
13.
And DW1.
PW1 also.
DW1.
DW1, huh? DW1.
On 26/1/94, I had a beetle shop in front of the court premises. I know the accused in dock. Identified accused Kalicharan. I do not know his name. on that day at about 10:15 a.m. to 10:20 a.m. He had come to my beetle shop to take beetle. He placed order for beetle and thereafter he came to the he went to the court premises to pass urine near the peepal tree. When he was returning, one old man wearing dhoti called him. It was visible to my beetle shop when that old man called and the accused went with him, and at that time his beetle was already ready, and I called the accused and he raised his hand and asked me to wait. Thereafter, he did not come to take his beetle. At about 11 a.m., I closed my shop and returned to home. It was Pausa Purnima.
How does he know all these things?
My lord, he has a beetle shop right in front of the court premises,
But
and he took
it's
beetle.
all right, but how he knows that somebody called the accused?
He was immediate in close proximity, my lord, as explained.
On that day, very.
He was in close proximity.
Court is
Therefore,
holiday.
he was able to call him also that come take your beetle, and he raised his hand to ask him to wait, and then he
I did not know the old man and called the accused and did not disclose.
ପୁଷ ପୂର୍ଣ୍ଣିମାରେ ଆଇଁଷ ହବ।
My lord, starting from his home to the meat shop, to the beetle shop, to the court premises, everything has been covered. Whether your lordship believes it or not, it has been covered by these witnesses. My lord.
You have tried to prove your defense
My lord.
through your 313 and prosecution evidence also, witnesses also, as well as defense evidence. That is your case.
My lord.
As well as defense witness.
My lord.
That you went to purchase for what you call
Things also started.
mutton, and you went inside. Some old man came
My
and
lord.
took you, and from that place to how you enter inside the room, nobody knows.
No, in the accused statement, in the 313 statement, my lord, he has himself said, I went inside with the old man, then some other people ganged over and
Blindfolded and took inside and
put something on my nose, and I fell down senseless.
straight away put inside the balcony.
And when I woke up, I frantically banged on the door, which has
Story.
been my
Story sounds good, but not logical.
I
Not
understand.
logical.
And also, my lord, the informant.
Therefore, I'm saying both your client and his client are very tactfully have done it.
Yes, that is there.
Very tactfully have done it. He is the court staff in Nazir or whatever. Sirastada. And you planned it on 15th of August. Deliberately, you thought that the police.
26 January also.
On January, the 26th January, you thought that the police will be busy and let us do it.
Yes.
That was the idea.
My lord,
I can smell it.
my lord,
Better stop it.
My lord, I beg to some.
To some extent, don't provoke me.
My lord, the standard of proof is still beyond all reasonable doubt.
That's
my
right.
lord.
You are right. There. That is the reason I'm hearing so much. Otherwise, it's a case of confusion. 2 minutes I could have diffused your opinions. There are gaps. But it is a case where you have done it. But the problem is there are gaps. File written note of.
My lord. Highly obliged. my lord.
You well argued. Well, yes. See, I'll 1 minute. Yes.
No, I was just informed by my learned senior that he's still in custody. Throughout the trial, he was in custody, my lord. 4 years, 5 months out of 5 years. My lord.
He's already, he's still in custody. No.
During trial.
Served out. Complete served out.
I'll verify, my lord.
Verify it.
My
Just check it up from the record. Tell me. And in the written note, you just note it. Yes. I just 1 minute. Yes, Mr. Acharya. Yes. Madam, have you got anything?
Except when I was the PW. Therefore, I have it.
If you don't have direct evidence, forget it now. I want that whether there is an abetment.
304.
306.
306.
From the evidence, it is very clear that this is a case of 304B. Okay? Because the court also says that 113 presumption operates, and evidence is very clear. It is a suicidal hanging death, and the aberrations and three antemortem injuries are also there. Everything is there. Despite that, the trial court says 311 presumption could have been employed, but I will not do it, and acquit him for 304B. If 304B is acquitted and convicted on 306, for the purpose of convicting 306, there need to be evidence of abatement. Where is the evidence of abatement? 304 easily he could have convicted. I can also convict. But you have not challenged that. Why should I, in his appeal, why should I issue notice and all this? I can issue notice also to enhance the punishment, whatever. But why will I do that? Neither it is that you have prayer, nor you have challenged it. It is a clear-cut case of 304B. The evidence is very telltale. But what to do? Therefore, you have to put some efforts.
Next week.
Otherwise, I will have to acquit him.
Next week.
Did you follow what is the problem with you? He has been convicted under 306 without there being any evidence of abatement. And acquitted at 304B.
PW1, PW5, PW8. Three relatives of the deceased. Mother, brother, mother and uncle.
She can develop the argument later get some time. Yes.
They have said that there was a consistent demand of balance 5,000. So she was asked to, their relatives were asked to pay that. So for unpaid 5,000 rupees, she was tortured, and she was also sent back to her matrimonial home, father's home, and she was also sent back to the matrimonial home. She committed suicide. That is what the case. And the Lawrence trial judge, what he did, he said that the marriage was held on 1998, death was in 2000, that is within 7 years, and there was a consistent demand of 5,000 rupees. So it is a dowry. He says that 304B case is made out, but reduced to 306. How can he reduce it to 306? Reduced to 306. There has to be a charge. 306 is something else, as has been held by my lord. I am referring to number of judgment of the Supreme Court that 107 parameters has to be followed. That there must be abatement or anything else that is absent. Then 306. Yes, I consider. Yes, there is a super court of the DPR is concerned. That is materials are available. It cannot be a case of complete accident. There has to be.
Just check it, madam. Take it. I'll put it on Thursday.
Paper book. I will not.
Take soft copy and do it. He's also doing from soft copy. Thursday, first item. Yes.
Next week.
No. I will read it again. I'll have to read it. Small issue. Why unnecessary? The other prosecutors are there. Why don't you help her? Why don't you help her? She is in personal difficulty. Somebody should help her.
Thursday.
Subhalakshmi is there.
Yes.
Sarita is there. Help her because she has some personal difficulty. There is small issue only. You check it up. Wait. Yes. Day after. Yes. Now there is another angle to it. All of them have said out. Prematurely released.
See, my Lawrence senior will also explain how the 321 is. Withdraw kemti karibe, my Lawrence senior will be explain.
No.
Prosecutor. You learn him.
My Lawrence senior is directed to make an application by the public prosecutor or assistant public prosecutor to government for withdrawal.
My friend, but
neither you know, nor he.
I am placing the 321 lordship. 321 lordship.
Why unnecessary? That is the reason I called the SP. You avoided that. Call the SP. I'll ask him how to move application. And 2003 the order was passed, and he should have moved application.
If that is the 2003 orders is not the lordship. that is the kind.
I am saying, my lord, only because this only report directed the informant to the state to move there. For that reason I am saying, my lord. 34.
Paper was called. Yeah, that is we the word is very used carefully in the 2003 order. Last.
How many accused persons are put to trial?
All total, my lord, faced trial, my lord. All total 30 persons, my lord.
So try 27
And
28 of them were.
one acquitted and my lord, another my lord expired during course of trial, my lord.
Out of those some original.
But in fact, my lord, conviction, my lord, against my lord,
28 people.
my lord. But in fact, total 30 persons, my lord. Okay. My lord, judgment at page, my lord, 6.
30 accused persons.
6.
30 accused persons.
Total 30 accused persons.
Stand charged.
My lord. But in
For offense under section 396, 427, 337, 325, public 149 IPC.
charge, my lord. But 302 and 325,
And also section 302, 325 and 324, 323, 324, 324 IPC. IPC.
in fact, my lord, conviction, my lord,
They were, however, 28 accused persons have been convicted for offense under section
395.
under 395.
All my lord, 395. Then, my lord, only my lord, 2
All
persons.
the 28 accused persons
395.
convicted under section 394.
395.
395,
95.
except one accused, Orokito Das.
Arita. And my lord, the Prabhato and Pitambara.
And the accused Prabhato and Pitambara were convicted under 324.
They have abated, they have expired in the meantime.
324, whereas Prabhato, Haribandhu Das,
Haricharan Das,
Haribandhu Das, Haricharan Das,
Banambar
Pradhan, Banambar Pradhan were convicted under 323 IPC.
Madhav and Nikuri acquitted.
Right. The accused persons were accordingly sentenced on each count.
3 years.
Each count. For 395, they were convicted. They were sentenced to undergo RI for 3 years, whereas for the offense under section 324 and 324, a sentence for 3 months imprisonment was awarded. The 28 accused persons, those who have been convicted for various offences, have filed the present appeal consolidatedly. During the pendency of appeal, कौन मर गया? अच्छा, during the pendency of appeal, appellant number 7, 8, 10, 13, 14, 18, 19, 23, 24, 25 have expired. Therefore, the appeal stood abated against them. In the present appeal is now concerned with the appellant number 1 to 6 and 9, 11, 12, 15, 16, 17, 20, 21, 22, 26 and 27.
28 is Pavitra.
28. 28 and 27 and 28. 27 and 28. Mr. Ragada,
28.
Who was appointed as an amicus curiae to assist this court in the present matter, has at the outset drawn my attention to the order dated 13th, order dated
order dated 24/3/2003, which reads agenda. Continue. He further submits that during the pendency of the appeal, the informant has entered into a settlement. Informant has entered into settlement with the accused persons and have also filed affidavit.
Affidavit is not mentioned, my lord, that order, my lord, fancy that order will show.
You filed affidavit? No.
The order will tell. Okay. Well, the order, my lord.
These order कुठले किती order express no
Anywhere we have said that you have entered into the. Anywhere you have said or in the during the trial they have settled or
No, during pendency of this appeal, my lord. Before this.
And is there anything on record to suggest that?
That order will pass by.
Which order?
Similarly, order dated 10/7.
Huh?
That order mentioned
10? No, here it is in 24/3/2023.
My lord, 20.
Dispute has been settled. Well, the point, this is recorded, but in the file, have you placed anything? Warrants are issued, huh?
Sir, anyway, available perhaps in the LCR, my lord, for the appeal here.
Warrants are issued.
Order passed by only the Sel Mahaputra and Valada. Done 3, I think, total 3.
NBW has not been executed.
Not executed. अपील का डिटेल लिखा है
कौन सा which is reflecting in the order dated 24/3/2003, which is extracted above. Subsequent thereto, on 17/11/2016, this court at this court also issued non-bailable warrant against the appellants, which appears not to have been executed so far. Executed so far. Wide order dated order dated 1/7/2025. Again, this court directed the Superintendent of Police Denkanal to ascertain the whereabouts and well-being of the appellants within a week and submit a report in that regard positively without fail. On that day, Mr. V.K. Ragada, advocate, was also appointed as an amicus curiae to assess the court. And the registry was directed to supply the copy of the paperwork to Mr. Ragada. Subsequent thereto, the matter was listed on 10/7/2025 and 2025. Is NBW issue at the time?
That is 17/11/2016 lordship annual issue.
The bail granted earlier was recalled and NBW was issued. And the following order was passed. 10/7/2025. 25. Who had given this report now? The
IIC Purna Court PSC lordship. District Hon'Ble.
So pursuant to the aforementioned order, by a report dated 5/8/2025, the IIC
Purna Court.
IIC
Purna Court Police Station.
Purna Court Police Station has filed a detailed report. The perusal of the report, 2012, perusal of the report reveals that all the surviving appellants have already been released from the custody prematurely after completion of their period of sentence. After serving out their period of sentence, the report has already been placed on record. In view of the aforementioned development, Mr. Ragada, learned counsel, amicus curiae, submits that you do not further press the appeal on merits. In view thereof, the appeal is disposed of, affirming the judgment of conviction as recorded above, and while affirming the order of sentence, the sentence awarded by the trial court being shared out by the appellants stands affirmed. Accordingly, the appeal is disposed. 92. 92, it's pending just month. 33 years, nothing is there.
Other data I have already pointed out about the district bifurcation district current to Hon'Ble SP may not given the report. Yeah.
Item number 37 was thought had. They will be taken up today or on hospital.
Thursday,
Provision number 61.
37 and 51.
37, 51 Thursday. 37, 51 Aparted out na sida. Tinta part
No, that's a day part.
What started you are without it, tinta. He will look over 37 or 97 meter. 37 and
51.
Oh,
37 because my mind was pleased to direct my arrangement to after the instruction.
Have you got it?
Question has not been put under 330.
That's the effect there.
You got it, na? It must be that substantively the question is put, then it is enough. It's not necessary that every bit. I know that's general principle. Let us see, examine that also. Let us see. That judgment, I know that judgment in civil side. Let us see.
1970, that ended up in 2025.
But substantively it has to be put, not that PW 1, 2, 3 and said everybody has said against you. What do you say?
That's civil be the position to know on that.
Let us see. Let us see. Okay. Thank you.